Letters. There is some mistake committed on our part in the petition. We have implemented wrongly response number 4.
You want to withdraw it?
Withdraw it, we will leave it to refile
Okay.
it.
Three, H.K. Sharma, learned counsel for the petitioners, has informed that due to inadvertence, some wrong wrong party has been implemented. Full stop. He accordingly prays for a permission to withdraw the writ petition with a liberty to refile. Full stop. Para. Considering the above, writ petition is dismissed on withdrawal with liberty as prayed for. Yes.
Refile it.
Direct mention item number 30, my lord.
30. 30.
30.
Yes.
Yeah, my lord, the department has filed their affidavit in opposition yesterday, my lord. So, my lord, I will be filing reply on Monday, my lord. So, I might, where is that, my lord, matter may fixed on Thursday, my lord.
Thursday, next Friday.
Next Friday.
Next
my
Friday.
lord.
Okay. 3S Hawk, learned counsel for the petitioner, prays for and is granted a week's time to file rejoinder affidavit. Para, on request, list on Friday next. Have you informed the other side?
Yes, sir. Irrigation department I have.
Okay.
My lord, another parameter for withdrawal, my lord, on Monday, my lord.
Okay, withdrawal, yes.
Okay.
Please, your lordship. Lordship, I beg to mention item number 48.
48.
Yes, lordship.
Yes.
Lordship, due to some personal difficulties from the engaged counsel, Lordship is unable to come to the court today.
Who is the engaged counsel?
Zebra SC ATPF, Lordship. Responded.
Okay. You've taken the consent of the other side?
Yes, yes.
Yes.
Page the fixed on 5th, my lord.
5th,
Okay.
on a request made on behalf of Sri J. Bora,
Zebra, yes.
learned standing counsel, ATEPFO. Matter is adjourned to be listed on 5/8. Okay.
Published.
I take mention item number 17, 18, 19.
Okay, fishery matters. Yes,
I have just, I got the affidavit and giving it to the lordship.
you'll be filing it today.
Today, lordship.
Mr. So what do you want? You
I
want
want
it?
adjournment, lordship. So the matter.
When? Tell us.
They
14?
are asking for 49.
Okay. Item numbers. Sri Sharma, learned standing counsel, Fisheries Department, has informed that the affidavit in opposition is being filed today. Full stop. That the affidavit, in all the cases,
In all that is.
that the affidavits be tagged with the respective records and the matters be listed on 14th, 17, 18, and 19.
And another matter, lordship, item number 21, lordship.
Yes,
I am for
AFDC.
AFDC, lordship. I will produce the record, lord. I was supposed to produce a record also.
My lord, on the last occasion, he had taken time to produce the record.
Yes.
Today he has some difficulty, he said.
When do you want?
Immediate, lordship. After 15 August, lordship.
Tell us when.
In full or means.
On 17th?
Lordship.
17th. On a request made by Sri P. Sharma, learned standing counsel AFDC. Matter is adjourned to be listed on 17th August to enable him to obtain the records.
My lord, we have an interim order in this case. no?
Interim order passed earlier stands extended till the next date of listing.
I'm obliged, my lord.
Obliged.
May I please, Lord?
Yes,
That's why I'd like to mention item number 8, Lordship,
Eight.
motion matter.
yes,
Lordship, this matter may be taken on Monday, Lordship. Petitioner want to engage a senior counsel.
okay. What is the matter about?
It's about the cancellation of the LOI, Lordship,
Okay.
by IFC.
On a request made by your name,
TH Chaudhary.
T.H. Chaudhary, learned counsel for the petitioner. Matter is adjourned to be listed on Monday next. Have you taken the consent? You have not taken the
Motion-
consent.
motion matter.
Motion, you don't have to take consent.
I will inform, Lord.
What I will inform? We don't want to report these things. Don't make a mention without informing, taking the consent. You know the practice.
I will do this.
Yes,
Obliged.
My lord, with the consent of the petitioner.
Yes.
To mention item number 40,
14,
no, 40.
40.
My lord, 4 weeks time may be given for, sir, for filing the counter affidavit,
You are for the FCI,
FCI,
inform the other side.
yes, yes.
Okay, on a request made on behalf of the FCI, 4 weeks' time is granted to enable filing of affidavit in opposition. Full stop. List on, we'll have it on 28 August. 28.
First week
28.
of September will do.
First week of September, okay, then we'll have it on 2nd of September. 29.
May I please, Lordship? Lordship, I beg to mention item number 6, Lordship.
6. Yes.
Lordship, this matter may be adjourned to the Lordship with the consent other side, Lordship.
You are for the petitioner.
Yes, Lordship.
When do you want?
Lordship, 5th August.
5th August, okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on 5/8. Item number 6.
Yes, Lord.
Okay.
May please, your lordship. Lordship, with the consent of the order, I beg to mention item number 41, lordship.
41.
Yes, lordship.
Yes, what
The
is it?
Nothing counsel, Mr. P. Bodoli is out of station, lordship.
When do you want?
Next week, lordship.
PNRD has been, you have informed the other
Yes,
side.
lordship. Yes, lordship.
On a request made on behalf of Sri P. Bodle Learned Counsel for the petitioner, matter is adjourned to be listed on 5th of August,
Yes, lordship.
5/8.
Lordship, similar prayer of item 44, lordship.
Same 44, huh? 5/8. Separate division.
Your Lordship, I would like to mention item number 20, Your Lordship.
21, yes?
20, Your Lordship.
20,
20.
yes?
Appearing on behalf of Bipal, Your Lordship.
On behalf of
Bipal.
Bipal, okay. What is it?
Lordship, we have received a copy of additional affidavit in opposition day before yesterday. So 1 week time may be given to file our reply in
Who has filed the additional affidavit?
Respondents, Your Lordship.
Respond Health Department.
No, Your Lordship, APDCL.
APDC is a party in item 20.
Yes, Your Lordship.
Health is also a party.
Yes, Your Lordship.
Okay, you want to respond to the additional affidavit?
Yes, Your Lordship.
What is your name?
Athena Buraguha, Your Lordship.
On the prayer of Miss T. Buragohai, Learned Counsel, appearing for the petitioner, 2 weeks' time is granted to file response to the additional affidavit of the APDCL. List on 14th of August. 14/8. Yes, Mr. Bora.
It's given to understand item 8 has been mentioned for third, my lord.
Item 8, we have not given, yes, 3rd, I think, yes.
Can it be taken up on 5th, my lord?
5th, yes, possible. 5th, huh? 5/8.
Alia.
May it please to your lordship. I beg to mention item number 31. Lordship, in this case, respondent have filed their affidavit. We
Yes.
need some time to file our reply.
Here for the petitioner.
Yes, lordship.
On a request made on behalf of the petitioner. 2 weeks, 2 weeks,
3
okay?
weeks time may be given, lordship.
You have taken the consent or not?
Yes, I have taken. Note.
3 weeks' time is granted to file rejoinder affidavit. Full stop. List on 19th of August,
Obliged, lordship.
19/8. Yes,
May I please, Lord? So in this matter, Lordship, the petitioner is the settlement holder of fishery, Lordship, for 7 years. Whatever, Lordship, petitioner earlier approached this honorable court on 2 occasions, Lordship. 2 orders were passed directing the respondent number 2, that is managing director, to consider the representations of the
for what? Representation for?
one for remission of 193 days due to late settlement, Lordship.
Oh,
And another is damage caused by the flood and erosion, Lordship.
yes. Then,
Without, Lordship, considering those directions, Lordship, notice was issued on 11/3/2026, Lordship, final notice for cancellation of settlement, Lordship. In response to that, we have filed a detailed reply and representation requesting that you consider the
the 7 years is expiring when?
729, Lordship.
29.
Lordship. It is 1/4/22 to 31/3/29, Lordship.
Okay.
7 years.
You are aggrieved by the notice of cancellation.
Prior notice of prior cancellation, Lordship.
Notice
They have
they are anticipating that it will be cancelled.
already
We are not cancelling.
final notice issued.
They are supposed to pay 36 lakhs, around 36 lakhs.
Okay.
And if we consider 196, then it will be around 4 to 5 lakhs rupees. So
Why don't you pay the
We are
outstanding?
ready, Lordship, but they have not considered our two repentant, 193 days.
they are with us for 4 to 5 lakhs, around 193 days. If we calculate lordship, then it will be around 4 to 5 lakhs rupees.
We issue a notice at this stage. You, there'll be no bar, there'll be, you, in the meantime, you consider and pass orders
Yes, sir.
All.
and do not take final action of thing, cancelling. But you have to make it endeavors to pay the amount.
Lordship, they are supposed to pay 36 lakhs and we are supposed to adjust 4 lakhs.
But another aspect is also they are
They may
damaged,
they may
but they have not passed any order, Lordship.
They may
as of-
Heard Sri M.K.
It's settled
Hussain,
now.
learned counsel for the petitioner, full stop. As per the facts projected, the 47 number Mora Kolong Min Mahal in the district of Morigaon has been settled with the petitioner for 7 years with effect from 1/4/2022 to 31/3/2029. Full stop. The petitioner had, however, submitted two representations, one for remission for 193 days, one for adjustment of the revenue for 193 days on the allegation that the fishery was handed over late, and the other for remission on account of loss suffered. Full stop. The petitioner had earlier approached this court by filing WPC 6392 of 2024. Full stop. The present grievance is, however, in respect with a notice dated
11/3/26, Lordship.
11/3/2026,
Page 40.
from which it is apprehended that the settlement would be cancelled. Full stop. Para. On the other hand, Shri P. Sharma, learned standing counsel AFDC, has submitted that there are huge dues pending against the petitioner, which pending even after even if some adjustment is made. Full stop. Para. Be that as it may, that notice be issued, returnable on 24th of August, 2026. Shri P. Sharma, the Learned Standing Counsel, Fisheries Department / AFDC, accepts notice on behalf of all the respondents. Extra copies be served upon him during the course of the day. Full stop. Shri Hussain, the Learned Counsel, prays for an interim order, which, however, is opposed by the Learned Standing Counsel by contending that huge dues are pending. Full stop. Para. Considering the facts and circumstances and by balancing the equities, it is provided that while no action for cancellation be taken till the next returnable date, the respondents shall consider and dispose of the representations said to be pending. Full stop. The petitioner would also make endeavors for payment of the dues. Full stop. On the returnable date, depending on the facts and circumstances, this court would pass further orders.
All right.
Mr. Sen,
My lord, in this case, we are appearing as legal aid counsel, my lord.
against the what is your grievance against the RBI?
My lord, the grievances, my lord, the petitioner, my lord, the learned ombudsman, my lord, without hearing the petitioners, my lord, passed the impugn order and thereby closed the, my lord, the application as well as the grievance raised by the petitioner, my lord, before the learned ombudsman.
There has been closure,
Closure, my lord, against
which
the
was challenged before the ombudsman. Closure of what?
closure of the complaint that we have filed, my lord, against the fraudulent loan that has been generated in my account, my lord, by the respondent number 3, Tata General Finance, my lord.
Of Heard Street, BKS and Learned Legal Aid Counsel for the petitioner who is aggrieved by an order dated 24/9/2025 passed by the integrated ombudsman.
Correct.
Integrated ombudsman, whereby the closure dated 17/4/2025 has not been interfered with. Full stop. The petitioner alleges that a fraudulent loan transaction was created by the respondent number 3,
Correct.
and this aspect has not been properly considered. Para, let notice be issued. Returnable on 28, 2026. RBI has a standing counsel.
Lordship, to my information.
P. Hazarika, I think. P. Hazarika.
Lordship.
Have you served?
I have served, my lord. I will serve extra copy.
No. You have not served. Their names are not there. Let steps be taken for service of notice upon the respondables 1, 2, and no. 3 R. Talukdar, learned State Council accept notice on behalf of respondables 4,
5 and 6.
5, and 6 extra copies. Steps for 1, 2, and 3. Speed post with AD. 2 working days.
Obliged.
Public.
Yes, Mr. Paul.
May it please your lordship. My lord, I am a applicant for a liquor shop license. The government has, so far the government is concerned, I have
On, off, what? Off.
off. All formality completed. I have even deposited the license fees of 15 lakhs and all. Now the local committee of that area who is away from my place, 1.44 kilometers, they lodged a complaint. The excise department, they conducted the inquiry. The inquiry is in my favor. But problem is that I have deposited such a huge amount. And my lord, because of this extraneous influence of that committee, probably on the other liquor shops, they are not issuing me the license. So your lordship will ask my learned friend to obtain the instruction on the next step, my lord. I
okay,
think it can be
okay.
disposed of.
How much amount has been?
15 lakhs.
15.
Go to say to. We have annexed the challans.
Heard 3 BD Core Learned Senior Counsel assisted by Sri J. Singh for the petitioner who is aggrieved by non-finalization of the aspect of allotment of an IMFL off shop in favor of the petitioner. Full stop. It is contended that sanction was granted on 11/12/2025, pursuant to which the petitioner had deposited an amount of rupees 15 lakh.
Yes.
Full stop. However, on the allegation, on the complaint by some committee which does not have any locus, comma, the matter has not been brought to a conclusion. Full stop. Let notice be issued, returnable on 28. Is it?
No, my lord, he says that he'll take only 1 week, but let him have till 10th of August, my lord.
Whenever you say.
10th of August, my lord.
12th of August, 12th of August. Sri P.N. Goswami, learned AAG, appearing for the Excise Department, accepts notice on behalf of
1, 2, 3, and 4.
1, 2, 3, and 4. Co-district commissioner?
5 also. Well.
5 also. 1, 2, 3, 4, 5. Extra copies.
6 and 7 will take steps, my lord.
So 6 and 7 by speed post with AD. Steps within 2 working days.
We are deeply obliged.
No more.
Your lordship has fixed it on
12.
Obliged.
But why are you opening in near a hotra?
It's 1.4 kilometer distance. They have a distance. We have qualified. It's more than 1.6 kilometers away.
You
We are not
look into that aspect.
Yes, but
If it is in the proximity, you may be right in not allowing.
no, it's
My
not in the prospect. They have a statutory distance. The
These
other
are
shops,
sensitive matters,
Yes.
Mr.
yeah, I
Gaur.
know.
You
but this
cannot just equate with
Yes.
inches and centimeters.
Malay, I think it is
You need to be
the
sensitive.
Malay, it is the other shops which are, I think, behind it, because I am not the only shop in that area.
Okay, take that instructions also. If there are no shops, then matter would be different, but.
Item 4.
May I please, Lordship. Lordship, one bi-weekly market, Lordship, that was settled in the last year, Lordship. Page 12 is the settlement order, Lordship.
It was settled with you.
No, Lordship, settled with someone else, Lordship. Lordship 2/7/25. This is the settlement order.
Yeah,
Lordship.
thereafter,
Thereafter, Lordship, there is no any initiation for the fresh settlement, Lordship.
is it extended?
No, Lordship. No, Lordship.
We only want initiation of fresh
Lordship,
settlement.
Lordship.
You're an aspirant for the new settlement process?
Lordship.
Okay. Heard ad hoc,
Lordship.
heard three ad hoc learned counsel for the petitioner. Full stop. As per the facts projected, comma, the petitioner is an aspirant for settlement of the Khuragaon biweekly market in the district of Murigaon. Full stop. It is contended that the earlier settlement was for a period of 1 year, which has expired on 30/6/2026.
Yes.
Until now, no action has been taken for settlement, for fresh settlement of the market in question. Full stop. Para, let notice be issued, returnable on, give a short date, madam, on 17th of, you take instruction, 17th August.
Steps been taken to sort of online tendering process, Lordship.
Hmm?
For that online tendering process, what the committee was formed. So some time will be required, Lordship.
17th, Miss P. Thapa appearing on instruction of Sri S. Dutta, Learned Standing Council PNRD accepts notice on behalf of respondent 1, 3, and 5. 1, 3, and 5. Whereas for video you can
Video.
1, 3, 4, and 5. Whereas Sri R. Talukdar, Learned State Council accepts notice on behalf of respondent number 2. Extra copies. Para, Ms. Thapa, the Learned Council, has however informed that there is a change in the procedure of settlement by adapting to the e-mode, and therefore some time is being taken. Full stop. Para. Be that as it may, comma, pendency shall not be a bar for initiating taking steps for settlement of the market in question in accordance with law.
Obliged, Lordship.
Lord, immediately after your lordships interfered with the suspension order, my license
Cancelled.
has been cancelled. Now lordship will issue notice at this
Okay.
stage, my lord. Cancel
Heard
it.
Sri K. N. Chaudhary, Learned Senior Counsel, assisted by your T. Kashyap for the petitioner. Full stop. As per the facts projected, comma, the license of the petitioner issued under the Assam Trade Articles within bracket licensing and control bracket close order 1982 was suspended, which was put to challenge in WPC 2057 of 2026. Full stop. In the meantime, comma, Ashoka's notice was issued. Full stop. As the final orders could not be passed within the statutory period of 90 days, as provided in the order of 1982, comma, this court wide order dated 17/7/2026 had interfered with such suspension and directed that the license be revoked, not revoked, restored. Full stop. It is, however, the case of the petitioner that immediately, that on the same day of the order passed by this court, the impugned order has been passed cancelling the license. Full stop. The Learned Senior Counsel has submitted that apart from violation of the statutory requirement, comma, the principles of natural justice has been violated and the order, impugned order, is arbitrary and unreasonable. Full stop. Para. Let notice be issued, returnable on 28, 28/8. Sri S. R. Barua, Learned State Council accept notice on behalf of respondents 1, 2, 3. What about 4? 1, 2, 3, whereas Sri N. Barua, Learned Standing Council, IOC accept notice on behalf of respondents 4, 5, and 6. That extra copies be served.
A small submission, Lordship, there is alternate remedy available. Appeal provision.
Okay.
Clause 28.
Extra copies be served. 3 Barua, the London State Council has however raised a preliminary objection that there is an alternative remedy in the form of an appeal. Full stop. The aforesaid submission will be considered on the returnable date.
Milord, instead of 28, could it be 26, Milord? 28 or something, 26.
26, okay, 26.
Deeply.
Obliged.
My lord, the petitioner is an appointed DPR consultant, my lord. He was to submit a detailed project report regarding the Gauripur bypass, my lord, construction. The report, my lord, was submitted in 2022, September 2022. That was finally, the report was, my employer was actually the PWD Assam. The controlling ministry, of course, the Ministry of Road Transport and Highways. My report, my lord, gets approved at page 49 by the ministry. At page 51, my lord, is the most pertinent thing, my lord. The high flood level, my lord, which is the issue of dispute, I had initially set it at, my lord, 32.06. But then PWD themselves, in consultation with the ministry, had then reduced it, my lord, saying that it should be at par with the railway bridge marking. And therefore, it had come down to, my lord, 30.915. Now, this was set, the report was approved. Then, my lord, in the year 2025, another committee was constituted, which committee, my lord, had recommended that the H7 level is actually 31.53. That is at page 74. Now, thereafter, my lord, I received a show cause saying that I had given a wrong recommendation, which actually was not my recommendation, which was actually the PWD and the ministry's own creation.
What do you say, Mr. Chaudhary? The basis of the show cause appears to be fallacious.
From the submission made by the and the pleadings, it appears.
You take instructions,
Yes.
don't take any action.
My lord,
What is the
question-
stage now?
Question is, my lord, the ministry has not issued any debarment order, but then they have written a letter to the PWD that I am already debarred. That is at Annex 10, my lord.
Already debarred.
Debarred, but then I have not
Ministry
received
has
any
written it.
communication.
Ministry of Transport has.
But in absence of any debarment, how will it be affected?
My lord, because this letter is given to all concerned, my lord, Chairman NHAI, RO.
This is issued by whom?
DCS.
Issued by?
This is issued by the chief engineer, sorry, this is issued by the assistant secretary, Ministry of Road Transport and Highways,
Central government.
central government.
Yes, central government, who's there? Is the CGC as a party here?
Yes, yes, my lord.
Yes.
Copies
Can
of-
you have CGC? Please inform. Wait for a while.
My lord.
Have you served or not? Mr. Pathak?
My lord, it is served. It's
Oh,
reflected
yes,
also.
names are shown. Why they are not responding? You have somebody. After a while,
My
Mr.
lord,
Pathak.
I'll
Item 10.
May I please your lordship? Lordship, petitioner before your lordship is that the earlier lessee of Bongalmara Weekly Market Thursday. Until 36/2026, he was running the market. So on 36/2026, he has filed an application that till new tender has been passed, he may be considered as extension. My lordship, thereafter on 1/7/2026, I take your lordship to Annexure 3, page 21, my lordship. They have issued, my lordship, an advertisement calling for bidders, in which a specific column was stated that only permanent residents of the respective legislative assembly.
Now, what is your grievance?
My grievance is that, my lordship, firstly, this eligibility criteria, which requires only the legislative assembly constituency, my lordship, since it's a Jilla Parikhad Bajar, my lordship. So every citizen under Lakhimpur Jilla Parikhad is eligible, my lordship. They have made a specific column in eligibility criteria stating only the legislative assembly constituency. My lordship is aware the Ranganodi constituency is newly formed. So this bazaar falls under this constituency, and petitioner belongs to Bipuria constituency, who was the earlier lessee. Secondly, my lordship, they have not opened bidders or like they have not called for formal tenders, only an extension in which they have done a pick and choose policy, my lordship. So I'm agreed by these two positions. Since I was the earlier lessee, till extension or if a fresh extension or till new is done, I may be considered or as such I have submitted.
Extension, is it possible under the law?
And my lordship, this.
There is a bar,
Yeah.
105.
Yes, my lordship, this.
You can very well put a challenge to the change in the criteria,
Yes, my lordship.
whereby you would be excluded
My lordship.
only because there is a delimitation of the constituencies.
Yes, my lordship.
That can be one point which we can consider.
I have raised, my lordship.
But extension as a matter of right, you cannot.
That, my lordship.
A new process has started.
No, my lordship. An extension is done and.
And when is the extension coming to an end?
It is coming to end by last Friday, but it has again extended to another 1 month.
Why are you extending?
And
This
this,
is the temporary settlement lordship. One notification is there till the e-tender process is started.
What about the other 105 violation? Can you do it? You do it through your own office. We have been passing orders, and you take steps for settlement. And in such settlement process, you allow the petitioner to participate,
That can be.
subject to further orders that may.
my lordship, and with regard to this, my lordship, humble submission is that since this advertisement, considering this specific criteria, is in violation, so my lordship, I'm praying for the office to run instead of the tender, respondent number 6, because it's a pick and choose to choose someone this particular.
No, this temporary thing cannot go.
My
They'll have to
lordship.
run from through the office. It's in violation of 105 and rules. Rule 47, is it? 47.
Yes, sir.
Heard Miss S.G. Barua, Learned Counsel for the petitioner. Full stop. As per the facts projected, comma, the Bongolamara weekly market was settled with the petitioner for the financial year, for the period 7/8/2025 to 36/2025,
26.
to 36/2026. Full stop. On such expiry, comma, the petitioner had submitted an application for extension. Full stop. However, on 1/7/2026, an advertisement has been issued for settlement of the market with a new eligibility clause that it would be restricted to the persons within the legislative constituency. Full stop. It is specifically contended that due to delimitation, comma, the market falls under the Ronganodi constituency, whereas at the time of settlement with the petitioner, comma, the same was within the Bipuria constituency, Bipuria,
My lordship.
under which the petitioner resides.
My lordship.
Full stop. The petitioner has also informed that temporary settlement has been done with the respondent number 6,
My lordship.
which is in violation of the statutory norms. Para, let notice be issued, returnable on 24th of August 2026. Ms. P. Thapa, Learned Counsel, appearing on instruction of Sri S. Datta. Standing Counsel PNRD accepts notice on behalf of respondents 1, 2, 4 and 5. Whereas Sri R. Talukdar, Learned State Council, accepts notice on behalf of respondent number 3, that extra copies be served. That steps be taken for service of notice upon the respondent 6 by speed post to AD, steps within 2 working days. Full stop. Para. The Learned Counsel for the petitioner prays for an interim order. Full stop. After hearing the Learned Counsel and by balancing the equities, it is provided that while this court is not inclined to stay the advertisement dated 1/7/2026, the bid, if submitted by the petitioner should not be rejected on the ground that he does not belong to the Ronganadi Assembly constituency. Full stop. It is also provided till the settlement process is concluded, wide the notice dated 1/7/2026, the department would run the market on its own.
Obliged, my lordship.
Lordship, kindly pass over for the time being. My senior is in place.
Who is your senior?
MD Bora, Corporation Department.
For Corporation Department. Huh? What is the matter, Mr. Kolita?
My lord, here my petitioner challenges the, my lord, the notice demanding the, my lord, revenues. Because, my lord,
Okay, we'll have it after a while. After a while.
So can it be in the second half, Lordship? Can it be in the second half, Lordship? I had some.
We'll have it immediately when she comes. Well, Mr. Ali, yes.
But here also, my lord, the petitioner is the existing lessee, my lord, and term has been expired on 30th of June, my
Yes,
lord.
yes.
There have no steps has been taken, my lord, for initiation of.
That is your grievance.
Lordship.
Okay, we'll issue notice. And we'll say that pendency shall not be a bar.
Lordship.
Okay. এই প্ৰথমটো যে মাৰিছিলা কোনটো আছিলে?
As item 4, my lord.
Item 4, huh? Item 4 হ'ব খালি নামটো হ'ব Kadong Bazaar in the district of Borkota. Our period আছিল 25/7/2025 to 36/2025. ঠিক আছে? Item 4 ৰ নিচিনা আৰু Madam Thapa for
All the.
all the respondents, all the respondents. আৰু তেওঁৰ হেৰিটো ৰাখি ক'বা যে ই মোডত হৈছে কাৰণে এই আছে যোনটো লিখিছিলো therefore সেইটো কৈ দিম okay অলপ চেক কৰি ল'ব ঠিক আছে okay you take steps
I'll take one.
give copies
Lordship. Obliged.
I didn't permit.
Mr. Chaudhary.
may please your worship. My lord, the petitioner was awarded with a contract, my lord, for a piped water supply. It was, my lord,
For
a piped water supply under the Jal Jeevan Mission. Jal Jeevan Mission. So he was, my lord, the scheme was for 260 families. And eventually, my lord, after the preliminary work order was issued in March 2023, it was found that, my lord, 260 families were not there, only 80 families were there. Then they also found that the village falls in a, my lord, forest, it is a forest village. And therefore, forest permission is required. Because of all this, my lord, the my lord, work could not be started, although, my lord, he has mobilized the materials. Thereafter, my lord, there was a standstill order, do not proceed. So that was there. Eventually, my lord, time passed by and the petitioner submitted before them that I am no longer interested in the contract. Please cancel it and, my lord, give me back my security, that my
performance
lord,
guarantee.
security.
Okay.
Now, after that, now they have said that you resume the work. Against that, petitioner has come, he has filed a representation, my lord, and his application is before them. That has not been addressed yet. At this stage, your lordship may issue.
Why can't you resume the work?
My lord, I am no longer interested because, my lord, I started the project with my lord, 260 families. Then it has been reduced to 20. My lord, I have spent quite a lot, and my lord, time has passed by. I am no longer interested in the work. They at one point of the, my lord, forest clearance was not
But
coming.
there would be some clauses for foreclosure of the contract.
Yes.
Is it there?
Oh, my lord, that has been considered by them. In fact, my lord, the
Did you apply to the authorities under that clause that you can foreclose under changed circumstances?
Oh, I have not stated that, my lord, specifically, but, my lord, there is communication from executive
But
engineer.
is foreclosure permitted?
It is permissible, my lord, the
Mr.
executive engineer.
Gogoi?
Lordship.
Chief engineer.
Chief engineer has written, my lord, foreclosure is permissible and it was, my lord, considered. Then, my lord, this.
We issue a short notice, but they take instructions.
Yes, sir.
2 weeks notice, okay?
My lord.
Heard Sri M.K. Chaudhary and his senior counsel assisted by Sri P. Bharadwaj for the petitioner. Full stop. Para. As per the facts projected, the petitioner was awarded the work of Krishnapur piped water supply scheme under the Jal Jeevan Mission for providing water supply to 260 households, for which the petitioner had also furnished performance guarantee of rupees 8,65,100. Full stop. However, it later came to light that the number of households were reduced to only 80,
80.
and some areas were also under the reserve forest where such work was not
It is a
permitted.
forest village, my lord.
Huh?
It is a forest village.
Some areas and the areas were forest village. Full stop. Under those changed circumstance, comma, the petitioner prayed for
Then, my lord,
foreclosing the contract and release of the performance security. The grievance of the petitioner is, however, with a communication dated 26/5/2026, directing him to resume the work. Full stop. Para. It is the specific contention of the petitioner that there has been change in the circumstances for which the contract in question is not is not in a position to be performed by the petitioner. And under those circumstances, comma, the communication dated 26/5/2026 is unreasonable and arbitrary. Para. Let notice be issued, returnable on we'll have it on 14th of
August.
14th of August. 3 R. Gogoi, Learned Standing Council PHC
All the respondents.
accepts notice on behalf of all the respondents. Let extra copies within 2 working days.
Obliged.
54 supplementary.
May
Mr.
be-
Boragoi?
My lord, on the last occasion, in this matter, my lord wanted me to have my lord, look at the full bench judgment of this honorable court, my lord. I have a copy, if I may.
No, we are aware of that.
So I have gone through, my lord, fundamentally, your lordship was, my lord, whatever point I have raised, my lord, has already been covered, my lord. But there is one part which I could see from this judgment, my lord, which is still, my lord, not been answered, a question of law, in fact, my lord, which has not been answered by this judgment, my lord. Quickly, if I may just take your lordship to that part, my lord. In paragraph number 18, my lord. I'll just read the relevant part, my lord. Since the government of Assam has agreed for disposal of the writ petitions in terms of their broad agreement to abide by the guidelines formulated in Jotin Pathok's case, with the aforesaid terms and conditions, we need not answer, my lord, this is important, the questions formulated as to whether the forum under Article 226 of the Constitution of India is appropriate to adjudicate the claims relating to the payment of contractual dues, and whether the writ petitions are required to be entertained in such cases in view of the broad agreement arrived by at and between the parties. We dispose of all writ petitions in terms of the agreement, my lord. My lord, I humbly submit, my lord. This
Full bench has endorsed the 3 principles laid down in Jotin Pathok.
Of course.
Full bench has not laid down the principle, but has simply endorsed.
Endorsement.
And
correct.
because of such endorsement, it is not required to answer.
Actually,
It stood answered.
but therefore, my lord, because I could also lay my hands on another important judgment which your lordship may have come across, my lord. This is 2004 3 SEC ABL International.
ABL was considered there.
Correct.
Hailal Bhai was considered.
Correct, my lord.
The Constitution Bench,
Correct.
64/1004.
So this judgment also speaks about, my lord, that the writ court can exercise the matters pertaining to contractual dues, my lord.
There's no dispute, provided there is an admission
Yes,
in
my lord.
writing
As
as held by the
Absolutely, my lord.
full bench.
Full bench, correct.
Full
my lord.
bench has not said it's totally not entertainable.
No,
You
no,
can
no,
entertain.
no.
Provided there you come up with a document that
Yes, ma'am.
there's an admission of the liability by
Yes, madam.
by the specified person, means the head of the department or chief engineer for works department.
Madam, in
Only
that-
on those. Otherwise,
of course,
we are not closing your doors. Your
Madam,
doors will be open.
correct, madam.
You
So
approach the civil court.
In that case, my lord, may I just humbly submit, my lord, that if I may be given a chance to, maybe, I do not know, my lord, that the department, I may proceed again to seek for an acknowledgement for the claim that is the balance part which is left with me until.
See, we are closing this only because you do not have the document.
Yes, my lord.
If tomorrow you are possessed with such a document,
My lord.
there will be no bar for you to
Come
approach
before
us.
this court, my lord.
Approach us.
Yes, my lord.
We are only for the timing saying that closure of this will not be a bar for you to approach the civil court. Okay.
And or any alternative remedy, my lord.
Okay.
Yes, my lord. I'm obliged, my lord.
Okay, heard. Sri H. Buragohai, learned counsel for the petitioners. Also heard Sri K.P. Pathak, learned standing counsel APDCL, full stop. The present petition has been filed with a claim for release of contractual dues of rupees 5 lakh 5,01,851.67, full stop. It is the case of the petitioners that they are licensed electrical contractors who were entrusted with a work wide letter of award dated 13/11/2021 for carrying out village electrification infrastructure under package 8 of the Deen Dayal Upadhyay Gram Jyoti Yojana in the district of Tinsukia. Full stop. The petitioners also claim to have successfully completed the work, and there is a work completion certificate, in spite of which the dues have not been cleared. Put the para. On the other hand, Sri Pathak, the learned standing counsel has submitted that the petitioners have not fulfilled the requirement laid down by the Honorable Full Bench in the case of Ramsar Ali versus so-and-so reported in so-and-so. Full stop. He has also submitted that there is an arbitration clause. Full stop. On the aforesaid point issues, the learned counsel for the petitioner was granted time on previous occasions. Put para. The petitioner, though, have enclosed a completion certificate, to entertain a petition for a direction for release of contractual dues by a writ court, the principles which have been endorsed by the full court in the aforesaid case are not to be fulfilled. Full stop. In the instant case, there is no acknowledgement of the liability in writing by the head of the department of the chief engineer, which is an essential requirement. Full stop. The availability of an arbitration clause would also come into the way of entertaining the writ petition. Full stop. Para. Under those conditions, the instant writ petition is held to be non-maintainable and accordingly closed. Full stop. Para. Closure of this writ petition would, however, not be a bar for the petitioner to approach the appropriate forum. Full stop. It is also provided that if the petitioner comes to possession of can fulfill the requirement as laid down by the full bench, the petitioner can approach this court in accordance with law.
I'm highly obliged, my lord.
The 3-year period will also be a
Where's
particular
that?
question which we.
Here will not come into play because my lord.
Although we are quoting it, we are doing that.
Yes. Anyways, my lord, I'm obliged, my lord.
Any other forum, if in accordance with law, upar. Closure of this shall not be a bar if permitted by law. Yes, Mr. Sharma, item number
55, your lord.
55, yes.
Yes. Your lordship, the petitioner here has been granted IMFL on license in the year 2019.
Okay.
And since then, he has been operating the bar and the restaurant. And at present, he has around 65 employees. And
Okay.
he has also paid taxes in the tune of 4 crores in the last 5 years. But suddenly, the authorities have issued this impugn order at page 27, whereby they have suspended my license without any issuing show cause notice.
Is it required? Suspension, so cause is required.
It is required because it has has effect of.
Otherwise, my lord, it is true, my lord, principles of natural justice is ingrained in a statute unless specifically.
No, no,
excluded.
for
But-
suspension.
Yes, it is not mentioned in the act, my lord. In some situations it might, but here is a case, my lord, they have admitted that yes, we have violated. So had we, even if we issued the notice, my lord, the answer would be same, my lord.
No, Mr. Goswami, the question posed by this court is on the context of suspension vis-a-vis cancellation.
Yes, my lord.
Suspension is a temporary
Temporary.
measure for which requirement of giving a show cause may not be mandatory in all cases.
Yes, my lord. Yes,
Suppose in a departmental proceeding, you don't put him to a notice before you suspend.
exactly.
There's no requirement.
No requirement.
If you put him on notice, entire objective will be lost.
Yes. So as regards the act is
But
concerned, it is a-
here, it's not a cancellation per se,
It's
it's
a
like a
suspension.
suspension. So for that is principles of natural justice required.
not required under the law also it is not provided. And additionally, my lord, they.
How long can you suspend? Is there any prescription of law?
No, no,
Then perhaps it
Because-
cannot be indefinite.
it cannot be.
Even under the order of 1982, the period is prescribed 90 days.
In fact, my lord, for
So we
the-
have held, we might construe that it's a temporary kind of a measure.
Yes.
PNG may not be required.
in fact, my lord, this suspension order followed by certain reports of the superintendent of excise, my lord, which suggests that either we may go for cancellation or for imposition of fine, my lord. It's a compoundable offense, my lord. They can pray for that. Otherwise, my lord,
case-
on record, they have said, my lord, the suspension order, my lord.
But have you proceeded against him? No.
Not yet, my lord. The report has come
Okay.
after the suspension order, and they have also submitted a reply, my lord, at page 29.
Admitting.
Admitting, my lord.
No.
So even if we issue a notice, my lord, if the result is obvious, my lord, only one result possible. The question of
No,
putting them to so cause notice is.
Your
not
lordship,
required.
our reply was that we have closed the bar. Only the food and the food service was going on because of a
These are
party
questions of fact.
and the music.
3 persons lost their lives, my lord, after drinking at their place up to 3 in the morning, my lord. That Madhura incident, my lord, 2 girls also died, my lord, and the driver, I thought. 3 persons lost their lives coming out from this bar, my lord.
You are not following the rules.
No, your lordship, this is the
You
first.
allowed liquor consumption after the prescribed.
No, the bar was closed, your lordship. We have categorically stated, but that is it's a question of fact. Let the authority take a decision. What I am on.
Yeah, you may be, you are correct. Question of facts those have to be ascertained.
But my prayer is, your lordship, it's been more than 3 months. The employees, the rent, everything is, the business is gone. Only thing I'm praying is to stay this and let the authority take a call. Let them take a call.
Since 24/4 order was passed, they have
It's been
waited.
three-
No, at this stage, we are not
Let
passing any
notice
stay.
go, my lord, I'll respond with an.
We are not
update.
passing stay after 3 months. And this kind of matters don't expect a stay.
Your lordship,
Yeah, but you complete the proceeding immediately, okay? He
may-
should not suffer
may I
unnecessarily.
just place one judgment of the coordinators.
For,
Similar issues without.
Regarding?
Suspension without.
we don't stay a matter of after 3 months, Mr. Sharma.
And just.
You don't show any judgment of any other court. We are not too much. After 4 months, where are the principles of injunction? You go for a toss. Fine day you come to the court asking for a stay and grant a stay. 3 months you have suffered and one day will grant a stay. What is this kind of thing?
No, lordship, they
Where is the balance of convenience?
lordship, they may take a decision. They have waited.
No, where is the question of you are paying for a stay? We are not
Stay
granting.
because there is apparently a violation of natural justice because.
So is that the only consideration?
No, no. that
for
is-
stay?
No, but they have not also taken, we have.
So is
responded.
it a case of stay on the first day? Cannot be.
I
You have to be
understand,
reasonable.
But also.
You
they-
have not come immediately on the next date
No,
that
no.
we stayed.
No, because we waited that they will take a decision. It's more than 3 months. They have not taken a decision also now.
That will be against you. Heard Sri S. Sharma, learned counsel for the petitioner who is putting to challenge an order dated 29/4/2026 issued by the district commissioner Kamrup M, whereby the IMFL on license of the petitioner has been suspended. Full stop. It is contended that such suspension has been done without any notice and there is principles and there is violation of the principles of natural justice. Full stop. It is also contended that sufficient time has elapsed and no further proceedings have been initiated, causing immense hardships and prejudice to the petitioner. Para. On the other hand, Sri P.N. Goswami, the learned AG, representing the Excise Department, has submitted that notice has been issued and the reply of the petitioner would show that they have admitted the allegation. Full stop. Para, be that as it may, comma. Let notice be issued, returnable on your short date, Mr. Goswami, 2 weeks. We'll have it on 14th.
14, my lord, I will be not in Guwahati. Let it be on
That is
place-
12th of August. Sri Goswami, the learned AG, accepts notice on behalf of, no, not you,
R.R. Gogoi.
Sri R.R. Gogoi. Learned counsel assisting Sri Goswami accepts notice on behalf of respondables 1, 2, and 3.
All-
On all the respondents. Let extra copies be served upon him. Put up on the next date. Let instructions be obtained by the next date, depending on which this court would pass appropriate orders.
Then in the meantime, they can take a decision on the basis of my representation, 14/5/2015.
The pendency of this writ petition shall not be a bar for consideration and disposal of the representation of the
14/5/2020.
representation 14/5/2026 of the petitioner.
Obliged, sir.
Sorry.
Mr.
Hello.
Yes,
Vice and High.
Apparently his case is in paragraph 11.
he says that he has already recommended a higher level, which was not followed, and now he is put to fault.
Yes, and his primary case is that the order of debarment has not been communicated to him. That reflects from NHS
10, my lord.
10,
10.
because it has not been endorsed to him.
My
We
lord,
issue not notice at this stage.
At this stage,
my lord, 10, my lord, I'm paying for stay, my lord, of 10, my lord. All my other projects
Don't
are,
take coercive action on that communication.
my lord,
Okay.
not to act upon this communication, my lord.
communication of June, 19 June, more than a month.
But
Right.
there is no action of debarment.
My lord. No,
There might be.
page 86, my lord, says that from the issue of this letter, I am debarred. But then this copy of debarment is not marked to me. It is marked to NHIDCL, Ministry of Road Transport, NHAI, all other.
But if what is contending prima facie that he has given a report of 32.016.
The correct measurements, whereas it was
It was not-
at the instance of the authority. If that is correct, Lordship, he has a case, Lordship.
Heard Sri Pathak, learned counsel for the petitioner. Full stop. The petitioner is aggrieved by a proceeding initiated right show cause notice dated 13/4/2026. Full stop. It is contended that the petitioner was engaged as a consultant for construction of
Not
the
construction, my lord, DPR only.
for preparing of the DPR pertaining to construction of the Gauripur bypass. Full stop. It is the specific case of the petitioner that in the DPR so submitted in September 2022, comma, the highest flood level within bracket HFL was stated to be 32.016 meters. Full stop. However, the same was changed by the authorities to
30.915.
30.915. Full stop. It is also submitted that subsequently there was a recommendation by a committee for the level to be 31.53 meters.
Right.
Full stop. It is submitted that though the measurement given by the petitioner did not suffer any fault, comma, on that basis, comma, the communication dated 19/6/2026 would suggest that the petitioner has been debarred from debarred for a period of 1 year.
1 year.
Full stop. It is submitted that the petitioner has not been intimated with any notice of debarment till now. Full stop. Para. let notice be issued, returnable on
I'll be appearing for 225, Lordship.
returnable on 24th of August 2026. Chief Engineer Public Works Department is Sri B. Chaudhary, Learned Standing Council PWD for one,
Rest I will be.
only one. Whereas Ms. L. Devi, Learned Council Assisting Sri R.K.D. Chaudhary, Learned Deputy AGI, accepts notice on behalf of respondent numbers 2, 3, 4, and 5. Extra copies. Footstop. Sri Bathak, the Learned Council prays for an interim order. Footstop. Para, prior facile, comma. The impugned action by which there is an indication that the petition would be debarred for 1 year does not appear to be reasonable at all. Full stop. This court has also it is also the specific case that no notice of debarment has been issued till date, has been issued to the petitioner till date. Full stop. Under those facts and circumstances, comma, it is directed that till the returnable date, comma, the communication dated 19/6/2026 shall not be given effect to, shall not be acted upon.
Instead of notice of, there have been order of department because.
Notice was given. Notice was given, order.
Cause notice.
Notice, we are saying that notice is not meaning that notice prior to the communication of department. Say communication of department.
Deeply obliged.
56.
Yes, Mr. Decker.
My lord, I am taken the construction, but instruction, my lord, but he could not get any instruction, means communication from the authority, my lord. Recent communications.
You have acknowledged the receipt.
Yes, but they have
Prior
fraudulently taken it.
Then you can take it up in a civil
Yes,
proceeding.
yes,
Okay.
liberty may be given, my
Okay.
lord.
I heard Sri B.M. Decker, Senate Counsel for the petitioner, who has approached this court for a direction for release of contractual dues. Full stop. It is contended that the petitioner was entrusted the work of construction of Mohila Community Center at Nonai Kuti, comma, and for construction of the cultural stage at the Nonai Para Tea Estate, and also for construction. How many works?
3 works, my lord.
And also for construction of brick boundary wall at Nonaipara Tea Garden Community Hall, which the petitioner claims to have been done and bills accordingly raised. Full stop. However, however, the bills have not been cleared, and accordingly, the writ petition has been filed. Full stop. Para. When the matter was taken up on the last occasion, that is 29/7/2026, comma, this court had recorded the submission of the Learned Standing Council of the BTC, as well as the Standing Council of PNRD department, that the petitioner did not meet the requirement laid down by the Honorable Full Bench in the case of Tamsir Ali versus so-and-so, reported in so-and-so. Full stop. It was further contended that the claims was barred by time. Full stop. Further, comma, a specific plea was taken that in page 45 of the writ petition, comma, there is an acknowledgement of receipt of the full and final amount. Full stop. Under those circumstances, comma, the Learned Counsel for the petitioner was granted time to obtain instructions. Full stop. Sri Deka, the Learned Counsel, has submitted that no concrete instructions could be obtained. Para? Upon consideration of the facts and circumstances, this court is of the view that apart from the claim being of the period 2016 and 17, there is no acknowledgement of the liability in writing by the head of the department of the chief engineer, which are amongst the essential requirements laid down by the Honorable Full Bench in the aforesaid case of Ramsir Ali bracket Supra, full stop. The acknowledgement of receipt of the full and final payment would also be a relevant factor for entering into the issue sought to be raised by the petitioner by this court, which cannot adjudicate disputed questions of fact, full stop. Para. Under those circumstances, the instated petition is dismissed, full stop. There would, however, be no bar for the petitioner to approach the appropriate forum if permitted by law. Full stop. ऊपर में लिख दीजिए हाँ, BMD का and B Bora for BTC and S Dutta, Standing Council PNRD. Mr. Borua, you are also there. SR Bora, State Council.
My lord, one submission may be recorded that they have taken it fraudulently, my lord. That 45. That is my submission, my lord.
With regard to the acknowledgement in, with regard to the receipt of the full and final dues, the learned counsel for the petitioner has submitted that such document, such signature has been obtained fraudulently. Full stop. Uska baad likhiye. Disputed questions of fact.
Much obliged, my lord.
ये मेरा यहाँ प्रिंट कर दीजिए. रेवेन्यू स्तंभ थोड़ा लिख लीजिए. रेवेन्यू स्तंभ में हम लिख देगा. लिख कर रखिए. रेवेन्यू स्तंभ याद कर लीजिए.
Let's kindly pass by for the time being.
57 why?
57 and 59 kindly taken together. 57 and 59.
57 and 59 together.
My lord.
Oh, Madam Bora, MD Bora, where is she?
She's in code 6.
Code 6. Okay, after a while.
No.
May please your lordship.
Yes, your name was not there on the last occasion.
Not served. It was served.
Yes.
This is a case, my lord, where all the bank accounts of the petitioners and his company has been blocked, my lord.
Bank accounts blocked?
Yes,
Why?
freezed.
Frozen?
My lord, frozen, my lord. Petitioner number 1 is the individual. Petitioner number 2 is a company on which the dispute arises. And my petitioner number 3 is a property firm where the petitioner number 1 is the proprietor, my lord. So whatever, my lord, if your lordship comes to the annexure 2,
yes,
page 24.
You have not fulfilled the statutory requirement of the ESIC.
Yes, my lord.
You have not.
No, my entire company is in a dormant state, my lord. That I'll come, my lord. Lord, can I give 5 minutes, my lord? Lord, can I see page 24, annexure 2?
No, if it is in a dormant state, you are not required to follow the ESIC.
No, my lord. I do not follow the meaning of factory, my lord, as per the act, my lord.
Let us see. ESIC. Yes, Mr. Smith, what do you say?
Exemption has to be granted under section 87, my lord. That
He has to
exemption-
approach. There has to be an order of exemption. Or it
Yes,
cannot
my
be
lord.
assumed.
My lord.
Everyone will say that my factory or my thing
Yes.
is in a dormant state. It has to be examined, assessed.
That's the thing, my lord.
Where has it been done? Did
Nothing
you
is done, my lord.
No, where have you approached?
My lord, kindly come, my lord. This is the certificate of...
Your contention that it was in a dormant stage
Yes, my lord.
needs to be first
Access, my lord, access by the-
brought to the notice of the authorities. Did you bring it?
No, my lord, since it was under a dormant state, my lord, nothing was operating. And my lord, they have.
No, this fact needs to be brought to their notice.
Yes, my lord, I
Well,
will bring, my lord, I will bring, my lord.
No, I will not do. ESI will automatically be in operation
My lord.
unless you make out a case that you are entitled to an exemption.
My notice was never served to me, my lord.
How will
Bank
that?
account has been seized. But that entire family will suffer out of this, my lord, terrorism, my lord. All accounts have been seized, my lord.
Notices were duly served, my lord.
Not-
Even
well,
before
full
passing
of
of
the-
the prohibited order, my lord, notices were order.
Well, can you see Annexure 3, my lord? This is the, my lord, CA report, my lord. No function, my lord, nothing. Then, my lord, Annexure 4. But this is my address, my lord.
Have you got the instructions?
I have the instruction. Notices were duly served, my lord. Before the passing of the order under section 45.
You know the,
it is
Mr.
given-
Das, you know the mandate of the ESI Act.
Yes, ma'am. Yes, ma'am.
Your hardships is on a different context. It is for the greater good of the
Yes, ma'am.
your employees.
For that,
You
my lord,
cannot overcome the.
my lord, I am already paying, my lord, my ESI, my lord, contribution, Annexure 11.
He may also approach the.
And what about the appeal?
He may approach this. He has not approached.
No, my lord. I will.
75.
75 or section 45 AA to the regional director. also.
You approach the regional director. 75 is there. 45 AA is there.
Lordship, kindly, my lord.
It would have exempted when if he have appeared, madam, long time.
Okay, kindly produce this now. Only for answer.
No, you come to the writ court with matters of facts, which perhaps we cannot be able to.
My all bank
Adjudicate.
accounts have been seized, my lord. Please, my
No,
lord.
that is the consequential
Please, please.
action.
Paragraph, my lord.
What are you showing Whirlpool at this stage?
My
Are we saying that it is why Whirlpool are you showing to this court?
Their condition is that whether it is applicable or not. Petition is applicable or not. But kindly see paragraph 15, my lord.
No, can you adjudicate the aspect that it was dormant, that you had intimated, not intimated?
And
These
moreover,
are
my
within
lord,
the domain of factual metrics.
moreover,
How
that-
do we entertain? We had to go into those facts.
my moreover, that demand amount has been taken by them, my lord.
Why don't you approach them under 45 AA or 75?
But
45 AA appellate authority.
my lord. They have taken the demanded money, my lord. They have still my accounts are freezed, my lord.
See, freezing of the account or consequential action.
Yes, my lord.
You cannot be just that. First, you have to challenge the root. Now, if you can make out a case of exemption, they will consider.
My lord.
They'll consider. Is there any limitation bar?
But if they approach, madam,
Is there any limitation?
45 AA is 60
60 days.
and employee citizen clause is 3 years. But it is their prerogative where they want to approach.
He can approach 45 AA. We can make some observations
My lord.
that he files it and on this ground of 60 days, you do not,
Yes, madam. That can be.
you consider on merits. Okay?
If there is a delay,
If-
also that can be also.
Yes, and if he's aggrieved, then his rights are there under the statute.
My lord.
Mr. Das, see,
But
there is no
one more thing, my lord.
problem in entertaining your petition, but ultimately you will not get
But one
anything.
more thing, my lord. They have taken away the demanded money, my lord. Still my accounts are freezed, my lord. That's my grievance, my lord.
Mr. Das, you can place all this before the appellate authority under 45 AA.
My lord, my lord.
Okay. How soon can you approach?
My lord, immediately, my lord, within 10 days, my lord.
Okay.
My lord,
Not
at
10
least-
days.
My lord, at
When
least
do you
my
need
one
10 days
account-
to approach
My
the
lord,
appellate
my
authority?
personal account may be, my lord, defeased, my lord.
Hmm?
My personal accounts, my lord, all accounts have been seized, my lord. But the entire family will suffer, my lord.
Personal account of whom?
Not petition number 1, petition number 2, petition number 3.
Personal, 2 is, what is a personal account? Petition number 2 is a company. How does a company has a personal account?
1 is the personal, my lord.
1 is a
one
personal
my
account.
lord, personal, and my lord, 3 is the
3 is also a proprietorship.
yes, he's the sole proprietor.
So proprietor,
He-
but it's a proprietorship.
Yes, my lord.
You have an account in the name of a proprietorship. How can you say it's a personal account?
If this is
How much amount? What is the amount in your personal account? How much amount are you holding?
that is I don't know.
You have to state that it'll make some change if you pass an order.
My lord.
Have you stated anywhere?
Number, not about the amount, my lord. How much amount is there, my lord?
He will also make a prayer, Mr. Smith. for passing interim orders for refreezing the personal account, we will consider. Okay.
And
Heard.
my lord, just a minute, my lord. But petition number 3, there are 232 numbers of workers working under this cooperative farm. If this is freeze, how can I pay the GST? How I will pay the salary of those persons, my lord?
So if you have not followed the statutory requirement and follow the ESIC, then can you come to the court? You have to first fulfill your duties, then before you approach the court. Heard Sri SP Das, learned counsel for the petitioners, as well as Sri M. Smith.
2 and 3, my lord.
No, don't say yes. Also heard Miss L. Debi, learned counsel appearing on instruction of. You are also CGC, learned CGC. Full stop. No, full stop, comma. Sri M. Smith, learned standing counsel, ESIC.
My lord.
Full stop. Considering the nature of the order proposed to be passed, comma, notices upon the response numbers 4 and 5 are not required at this stage. Full stop, para. The petitioner, the petitioners are aggrieved by the action of putting a lien oblique freezing of the bank accounts. Full stop. It is contended that the petition number 1 is petition number 1 is one of the directors of petition number 2 company and the sole proprietor of the petition number 3. Full stop. The petition number 2 company, which was incorporated on 18/10/2022, however, has been claimed to be in a dormant stage since its inception and does not fall under the ESI Act 1948. Full stop. It is also contended that the authorities of the ESIC never visited the office of the company for any physical verification. Full stop. However, demand notice dated 4/5/2026 and prohibitory orders dated 6/7/2026 has been issued directing payment of contribution of rupees 1,71,525 to the ESIC. Full stop. Thereafter, the impugned action of putting the bank accounts of the petitioners on lien has been taken. Full stop. The learned counsel for the petitioner has submitted that since the petition number 2 company was in a dormant state, comma, there was no obligation under the ESI Act of 1948, and therefore the entire demand and the subsequent action of freezing the accounts are illegal and arbitrary. Para contra, comma, Sri Smith, the learned standing counsel ESIC, has submitted that all actions are taken in accordance with law, and the consequential action of putting the bank accounts on lien, oblique freezing those, are only on the aspect of not paying the contribution as per the demand notice. Full stop. He has also drawn the attention of this court to the provisions of 45 AA as well as 75 sections of the ESI Act of 1948, which provides for an alternative efficacious remedy. Full stop. Para. Sri Das, the learned counsel for the petitioner, has submitted that availability of alternative efficacious remedy, availability of alternative remedy would not be an absolute bar for invoking the writ jurisdiction, and in this regard, he has placed reliance on the case of Whirlpool Corporation versus Registrar of Trademarks, reported in 1998, 8 SCC, page 1. Full stop. Para. While there is no dispute to the proposition laid down by the Honorable Supreme Court in the case of Whirlpool, wherein there cannot be an absolute bar for exercise of judicial review by a writ court, comma. It is a rule of prudence that when there are questions of fact which are disputed in nature and the alternative remedy provided is efficacious, comma, the writ court, the powers to be exercised by a writ court which are prerogative in nature may not be invoked. Full stop. Para. This court is of the prima facie opinion that the remedy provided under section 45AA/75 of the Act would be the appropriate remedy in view of the fact that, amongst others, there would be disputed questions of fact on the aspect as to whether the company in question within bracket petition number 1 was in a dormant state or not. Full stop. Para. At this stage, comma, this court has noticed that section 45AA contains a limitation clause of 60 days. Full stop. Considering, but 60 days, I think it's still, you'll be, I think, covered.
Yeah.
60 days, full stop. Consider in the conspectus of the aforesaid discussion, comma, this court is of the opinion that this writ petition would not be maintainable, full stop. Would not be, and accordingly the same is closed, full stop. Closure of this writ petition, however, shall not be any bar for the petitioner to approach the appellate authority under section 45AA or the Employees Insurance Code under section 75. Full stop. It is also provided that if there is any delay in such approach, comma, the petitioner may make appropriate prayers for condonation of the same, which will be done, and the case of the petitioner be decided on merits by giving adequate opportunity.
One page 14, madam.
Yes.
Page 14, the paragraph number 12. The amount which they have demanded, they have already taken it, madam. Taken away, madam.
He has also contended that the demanded amount has already been recovered from the petitioner, and therefore there is no occasion for freezing the bank account. You look into this aspect, if there is no contribution pending, then why do you? It will almost look like a penalty without.
60.
Yes, item number?
Item number 60, Lordship.
60. Yes.
Lordship, the petitioner's Lordship PDS license has been suspended by an impugned order dated 26/2026. Lordship, the allegation is that Lordship, the secretary has misappropriated the MDM rice and they found shortage of 85.644 quintal. And now, Lordship, the secretary, Lordship, is the relation of between the secretary and the board of directors is servant and Lordship, the master. And Lordship, these are reported case, Lordship.
Yes, we issue notice. You take instructions.
Otherwise, Lordship, the appellate provision is there before the district commissioner.
No, that would be between from the only order passed by the registrar of society. This is an order passed by the co-district commissioner also.
Court is by the capacity of licensing authority, Lordship.
Okay, heard Sri S.K. Das, learned counsel for the petitioner, who is aggrieved by an order dated 26/2026, whereby the PDS/TPDS license of the petitioner society has been suspended. It is submitted that the allegation is that the secretary of the petitioner had indulged in malpractice. Practice, and it was found, and a shortage of 85.644 quintals of rice was found. Full stop. Para. Sri S.R. Barua, the London State Council has however submitted that the order in question is appealable. Full stop. Para. Be that as it may, comma, let notice be issued. Returnable on 17th. You take instructions. 17th. 17/8. 17, or we can have it on 19th. 19/8. Shri Barua, the London State Council accepts notice on behalf of all the respondents.
All respondents.
All the respondents. Let extra copies be served upon him by within 2 days.
Lordship, the secretary has already given an undertaking to return the thing, and also we have already taken resolution. We have already released it from the society, Lordship. So, Lordship, I am praying for an interim order, Lordship. Restoration. Lordship. Otherwise, Lordship,
The interim prayer for interim order would be considered on the returnable date on receipt of instructions. You will look into the respect if there is no connection with the misdeed of the secretary vis-a-vis the petitioner. Then perhaps for his fault they could not sooner suffer. Look into the respect.
Obliged.
Operation ahead nahi. Why chal nahi? 61, yes. Mr. Decker?
We are in a very narrow compass. Though there is an alternative remedy of arbitration, we have, before your lordship, challenging a termination order of the contract because they have not issued a notice.
Which department?
It is Department of Lordship, Steel Entrepreneurship.
Yes, who appears? You would be
And also, though lordship, the termination order of May, there is certain negotiation and they have also taken some performance from us, and eventually they have invoked the bank guarantee in July. So our main grievance is with regard to the invocation of bank guarantee.
Bank guarantee invocation, how do you come to a writ court, Mr. Decker?
We understand, lordship, but we also challenge the termination order because that forms the basis of
Appropriate forum is a civil court.
the Section 9 of the Arbitration Act would be the.
No, 7, 9 you can approach, but civil suit also would be bank guarantee injunction you have to pray for. And injunction can be granted by the under Section 9 also.
Yes, sir, that is also correct. And but the termination order is without following the natural justice process there because the notice of default is of May. And
the termination can be the subject matter of an arbitration.
Yes, Lord.
But prior to the arbitration, you can definitely approach Section 9 court. Okay, I will come back in 5 minutes.
Okay.
Rest of the respondents, full stop para. As per the facts projected, comma, the petitioner was entrusted with the work of design, development, and implementation and maintenance of the ASU Digital Campus for IT01, in connection with which, comma, a contract agreement dated 11/3/2025 was executed. Full stop. The petitioner is, however, aggrieved by an order dated 4/5/2026 issued by the respondent university, by which the contract has been terminated. Full stop. Para. During the course of deliberation, comma, it has, however, come to the notice of this court. In the deliberation, comma, the learned counsel for the petitioner has fairly submitted that there is an arbitration clause. Full stop. He has, however, submitted that apart from challenging the order of termination, comma, the petitioner also has some interim prayers. Full stop. Para. This court is of the opinion that Sri Barua, the learned state council, has submitted that in presence of the arbitration clause, comma, this petition is not liable to be entertained. Para. This court is of the opinion that the parties had agreed to a dispute redressal mechanism by way of arbitration. Full stop. It is also not in dispute that under Section 9 of the Arbitration and Conciliation Act 1996, the petitioner would be at liberty to approach the appropriate court for interim relief pre-initiation of the arbitration. Full stop. Para. At this stage, the learned counsel for the petitioner has submitted that the petitioner would invoke the arbitration clause and also approach the appropriate court under Section 9 of the Act of 1996. However, he submits that for a limited period, a direction may be issued not to take any coercive steps against the petitioner. Para. Considering the above facts and circumstances, this writ petition is closed by giving liberty to the petitioner to approach the appropriate court under Section 9 of the Act of 1996 in accordance with law. Full stop. It is further provided that if such approach is made on or before 10th of August, no coercive action be taken till the said date. Full stop. As it is needless to state that the petitioner would be, needless to state that the learned court, if approached, would pass appropriate orders strictly in accordance with law.
Highly obliged, Lord.
May it please your lordship. So the issue herein is regarding the illegal assumption of authority of the Dorong Jila Porikar vis-a-vis collection of tolls against a market where, as per the law, the proposition of law says if a market settlement value is below 5 lakhs, then it will be the sole jurisdiction of the Gao Panchayat. If it is from 5 to 10, it will be Anchalik Panchayat, and beyond 10,
lakhs.
The toll collection.
10 lakhs.
10 lakhs, yes, lordship.
Less than 5, Gao
Less than
Panchayat.
5 is the Gao Panchayat. And this will be true insofar as regular
5 to 10.
5 to 10, Anchalik Panchayat.
Above 10.
Above 10 will be, lordship, the Jila Porikar. And this finds mentioning in clause.
Okay, then what is your grievance?
My grievance is that the concerned market that we are talking about in this particular case is Ambachok cattle market. This market for last 5 years, the settlement value has been below 5 years. I have categorically stated in this writ petition, along with supported documents that I have annexed in the petition, that this market for last 5 years, the settlement value has been consistently below 5 lakhs.
5 lakhs. So it's the Gao Panchayat who has been doing it.
Therefore, even in matters of temporary toll collection, because a regular settlement has not been given, the authority will be based upon the Gao Panchayat. Now, the Act as well as the government guidelines provides the same. I do not think there is any dispute regarding the legal proposition.
Then what has happened?
Now, if your lordship will come to the impugn order at page 62.
1726.
Yes, lordship, 1726. The Dorong Jila Porikar have issued an order to their peon for collection of the tolls from vis-a-vis this particular market.
But the collection of tolls, can you equate with settlement?
Yes, lordship. Because settlement is ultimately regarding tolls only.
No, it's Jila Parishad doing it. What is the reason Jila Parishad has the?
If a lordship may just also see this.
I have to take instruction on regarding that, my lord. But the things are, my lord, let my friend comment.
One aspect regarding temporary settlement also, the government guideline page 59, the lordship will see.
59.
This part has been cleared by the government, lordship. By the executive order at page 59, the lordship will directly come to 7. Serial number 7.
Yes.
In case of failure in settlement of any assets, the concerned Gao Panchayat, Anchalik Panchayat or Jila Porishad will manage such assets and decide as decided by the next higher body, i.e. Anchalik Panchayat in case of Gao Panchayat, Jila Porishad in case of
settled. There has to be a failure first.
So this is a case of failure. So my case is, this Ambashak market is not being given for regular settlement. So therefore, there is a failure in settlement. Today, the situation is the market is not under any settlement. So therefore, temporarily, it has to be managed. The management indicates collection of tolls. There is nothing beyond that. It's basically they will collect the tolls. So therefore, this clause 7 of the executive order says that if the market is not been settled, then it will be, the assets will be managed by either of the panchayat lordship. And if your lordship will see the act gives this ceiling. Section 105, subsection 7 gives this ceiling of 5 lakhs, 10 lakhs and above also.
No, see, won't this come against you? Won't it go against you? 59(7). If there is a failure of settlement, then the Gaon Panchayat will not have the jurisdiction. It will be the Anchalak Panchayat, the higher.
If your lordship will see then 1 and 2 first, then lordship. I'll just read 1 and 2
No,
first.
please read 7.
Yes, lordship. In case of failure in settlement of any assets by the concerned Gaon Panchayat, Anchalik Panchayat or Jila Parishad or the Jila Parishad, will manage such assets. So the language is in case of failure in settlement. That is one part of any assets.
Yes.
That there should have been a comma, I believe. The concerned Gaon Panchayat, Anchalik Panchayat or Jila Parishad will manage such assets as decided by the next higher body.
Okay.
So the next higher body will decide as to who will run the market.
That means in your case, Anchalik Panchayat.
My argument, for me, my decision will be taken by the Anchalik Panchayat.
Yes, that is what we are trying to say.
Yes. Now the Anchalik Panchayat will necessarily have to decide in favor of the Gaon Panchayat in view of the prescription of the Act, section 1057, which provides that anything beyond 5
Yes,
lakhs
Mr.
will have to be settled by.
Yes, what is on?
At first, this is not a failure of settlement, my lord. This is by administrative orders, my lord. Government has, my lord, directed all the state, my lord, to hold the settlement and go for temporary settlement, my lord.
Yes.
Because, my lord, some upgradation is already aware, my lord. Some upgradation is going on, my lord. And first, before that, my lord, the petitioners, my lord, petition number 1 and petition number, there are 2 petitioners. They are only ward member, my lord. The Anchalik Panchayat is not before this court. Because grievance is, my lord, that the Gaon Panchayat and Anchalik Panchayat may have the, my lord, power of settlement, but the Anchalik Panchayat and Gaon Panchayats are not before this court, my lord. Only 2 individual members.
I think he has not read the brief properly. 18 and 20. Under authority of the standing committee of the Gaon Panchayat and the Anchalik Panchayat. Page 18 and page 20 I have annexed, lordship.
The resolution is different, my lord, but the
page
Gaon
18 and
Panchayat
page
Anchalik
20.
Panchayat is not before this court. That is my first objection, my lord.
Page 18 is the.
No, it will be authorized to espouse on behalf of the Panchayat. Where is the Panchayat before us? You will espouse on behalf of the Panchayat, represented by so-and-so.
Yes, lordship.
Panchayat is not before us.
No, lordship, if your lordship will see the resolution at page 18.
As per the resolution, Panchayat has to come before. Panchayat comes through whom? Through some person by a resolution. Those persons will not have the locus. They will have the locus only to represent.
We as members will indirectly have the locus otherwise also, because we are responsible.
Members can espouse the cause of the Panchayat.
So as a member of the Panchayat, I would also individually carry a responsibility to espouse this cause, because ultimately the toll collection is coming for the development of my Gaon Panchayat area.
We are not agreeing with this. What prevents the Panchayat from coming? First, you have to cite a good reason that the Panchayat for this reason is not able to come.
The Panchayat standing committee took a resolution saying that this is an issue that has to be taken up departmentally.
Standing committees should come before us.
And authorized.
The standing committee should come before us. Panchayat should come before us. Panchayat is a legal entity. It's the Panchayat's cause of action. How do you
espoused by a member of the Panchayat lordship?
You can represent. You can represent.
No, I mean,
you can represent. You can file the affidavit.
Individually also, I believe the locus would be there to raise this issue.
The locus would be there if there is some grave difficulty for the Panchayat or the legal entity to come to the court. We cannot make it a routine thing. We do not know what is the other person's, other members' views.
But I am raising a legal issue, lordship. It's not about only about the views per se, the members. It's a
Legal issues
legal issue.
will decide when the appropriate person comes before us. You withdraw this and come, let the panchayat come. You already have a resolution.
Yes, Lord.
Where is your resolution?
Page 18 and page 20.
1-8.
18 is by the Gao Panchayat and 20 is by the Anchalik Panchayat. Because Anchalik Panchayat's decision has also been, I mean, the Anchalik Panchayat could not take a decision on this aspect as provided under the
18.
executive orders.
18 is what?
18 and 20, Lordship. 18 is the Gao Panchayat. General Standing Committee is the authorized body to take decisions on so far as settlement is concerned, as per the Act. And at page 20 is the resolution of the Anchalik Panchayat. Because the decisions have been taken by the Anchalik.
They let the appropriate person come.
The Lordship will record this and allow me to withdraw with the liberty to refile.
Yes, heard Sri A. Sharma, learned counsel for the petitioners. Also heard Sri S. Datta, learned standing counsel PNRD. Full stop para. The petitioner number 1 is a member of the who you are whom?
Abhay Pukhuri, Gao Panchayat. I am Ataur Rahman Chaudhary.
The petition number 1 is a member of the Abhaya Pukhuri, Gao Panchayat, whereas the petition number 2 is a member of the
Pub Mongoldoi,
Pub Mongoldoi Anchalik Panchayat.
Yes, Lord.
Full stop. The grievance, it has been contended that so far as what is the name of the market?
Amba Chowk Cattle Market.
So far as the Amba Chowk cattle market is concerned, for the last 5 years, the settlement amount is less than 5 lakhs. And therefore, the concerned Gao Panchayat had issued the settlement orders, full stop. However, by the impugned order dated 1/7/2026, the Darang Jilla Parishad has authorized its peon to collect the tolls, full stop. The learned counsel for the petitioner has drawn the attention of this court to the executive order dated, what is the date? 21/5/2025, as per which, 2025, more specifically, clause 7 thereof, as per which, in case of failure in settlement, the assets will be managed as per decision of the next higher body, full stop. He has submitted that though settlement has not been done, the present arrangement could not have been. The present arrangement would be in violation of the aforesaid executive order. Full stop. Para. Sri Datta, the learned standing counsel, has however submitted that the executive order would not apply in as much as there is no failure per se in making the settlement, and only because of a new mode being adopted, there has been certain delay, full stop. He has also raised a pertinent point that neither the concerned Gao Panchayat or the concerned Anchalik Panchayat are aggrieved, and only 2 members of the respective panchayats are before this court, full stop. Sri Sharma, in his response, has submitted that the petitioners have been duly authorized by resolutions taken by the respective standing committees.
General Standing Committee.
Para. While the resolution by the standing committee is not put to doubt, the requirement of law is that the aggrieved person / legal entity should approach the court, full stop. At this stage, the learned counsel, the Sri Sharma, the learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition with a liberty that the concerned Gaon Panchayat / Anchayat Panchayat would approach this court in their as legal entities, full stop, para. In view of such submission, comma, the writ petition is closed by giving liberty as prayed for.
Yes, Your Lordship. Obliged, Your Lordship.
In the meantime, you see this 59. It might have an impact in the decision making.
In fact, my lord, there is another section in the Act, my lord, which says, my lord, if any disputes between, my lord, in the bodies, my lord, the government has to take decision.
No, that is okay. But now if there is a delay in settlement, then the tolls or whatever can be collected by them, not
Yes,
by the
yes,
Jilla
by
Parishad.
jurisdiction only, yes.
Because the money would come to us
Yes, yes.
as per the act, scheme of the act.
How does the Jilla Parishad just barge in and have their
I understand.
peon collect the tolls?
Section 1056 deals with distribution of the money. So therein the
Okay, let us see.
Yes,
Come.
obliged.
Let the appropriate person come. Yes.
Yes, Lord.
Sir, I'm extremely sorry, my lord. I was on legs.
Yes. Yes. Mr. Kolita.
Well, here, well, the lordship will find.
No. As transport corporation. Okay. What is it, Mr.?
But we have challenged the Annexure 24, page 147. Petitioner is the valid settlement holder. Of fishery, two fisheries, analogous fisheries too. And some sale points were also allotted.
You are the settlement holders of two fisheries.
Yes, my lord. So, my lord, both the fisheries, there are, my lord, few, my lord, sale points, my lord, markets allotted to the petitioner society. My lord, subsequently, what happened, my lord, those sale points were, my lord, closed by an order issued by the government. Lordship will find at page 59 that with an observation that they can sell their yield, my lord, at the area of operation as provided by the societies of the register of the society, my lord. So, my lord, they thereafter they could not sell their, my lord, fishes, so they are suffering loss. Then they, my lord, filed several applications before the authority.
Why you could not say sell the thing area of operation in the
Area of operation, according to the, my lord, authority, that area of operation of the my lord, the society, my lord, they can sell their yield only in the area of operation of the society.
Yes.
No, not of the, my lord, fishery. So, my lord, their, my lord, area of operation, definition of area of operation is, my lord, from where the member belongs of the society.
So what is the problem in having the sale done in the area of operation?
The area society is far away from the, my lord, fishery. It is almost, my lord, 35 kilometers away. So, my lord, nearby markets, initially, my lord, authority allowed the petitioner society to sell the yield, my lord, at the nearby markets. But subsequently, another, my lord, cooperative society complained. On the basis of that complaint, my lord, the petitioner society was restrained. So, thereafter, petitioner filed several representations for redefining the sale points. But that was not done. Thereafter,
But the settlement, area of operation is not a criteria for settlement. It's the neighborhood.
Lordship may kindly.
If you are having your area of operation 35 kilometers away from the fishery, how were you settled?
That is what, my lord. Lordship may kindly come to page 36.
Area of operation is not a relevant criteria. Neighborhood is the relevant criteria.
From the very inception of the settlement, they are suffering the difficulties. Initially, route has been changed.
Now, what is your grievance? What is
grievance,
the
my lord? They have initially. I approached this honorable court, lordship. Initially, also Annexure 18, page 129, they have issued a demand letter demanding the kist money. But we have submitted a representation for redefining the sale points and for exemption of the revenue. Thereafter, we approach this honorable court. Lordship will find that page 133. Then this honorable court directed the petitioner to file an appropriate application before the authority for redressal of his grievances. Accordingly, on 27/6/2025, page 137, my lord, and a representation was submitted before the Commissioner and Secretary, Government of Assam Fisheries Department.
And another application, my lord, was submitted.
Mr. Kolita, we are not impressed by your case projected. You are not able to sell your fish.
Yes,
We are not impressed
and
at all.
since, my lord, 2023, my lord.
These are all tactics to avoid the kiss money. We are not impressed at all.
Lordship, let the.
Why don't you surrender the fishery?
My lord.
Why don't you surrender the fishery? Surrender the fishery. It's not been you have not been facilitated to make the.
December, my lord, settlement period will be over.
Then after running, now you're saying that because you could not even sell the fishes.
Since 2023,
This is something.
December 2023, my lord. And my
You
lord,
come up with some.
kindly
You
see,
come up with some facts or some stories which are believable.
Lordship, may kindly see page 146 for a moment, my lord. 146.
We are not impressed.
146.
You get the settlement thereafter for at the time of paying the revenue, you come up with
146
excuses.
last paragraph. Lordship will see.
146.
Last paragraph.
Yes.
This is the representation they have disposed of, my lord.
Hmm.
Copy of which was never served.
Peruse the petition that is so-and-so, Vikas Das, Dibru so-and-so.
Paragraph
Seeking
3.
waiving of fishery.
Third paragraph.
And reopening of fishing selling points. Thereafter, what had happened?
Thereafter,
but prima facie, the learned, the co-district commissioner has come to a finding that this prayer of years is not entertainable.
Yeah, because he has no jurisdiction.
Thereafter, no, before that, jurisdiction is different matter. See paragraph 2. Upon perusal of the petition, it is observed that the closure of the selling points at so and so are specifically mentioned, and it is stated to be the reason for which they were unable to carry on the selling activities for the past few years. However, the same cannot be justified and considered as the ground for exemption revenue settled with the lessee per month.
Yes.
He prima facie is of the opinion. This
Fourth
cannot
para,
be-
my lord. Fourth para.
Fourth we have seen.
However, since the decision to wipe off the revenue.
There we have seen. That is only for waiving of the decision. He
Yes,
cannot.
and for the redefining the sell points.
Thereafter, what happened?
Thereafter, my lord, this order they have provided us, my lord. And we have submitted my lord, already we have submitted an application. Lordship will find at page 137.
See, second paragraph, it has however been observed that your society has neither surrendered the fishery nor cleared the outstanding dues. The
Yeah.
option to surrendering was there. You did not abide by. You don't have any case, Mr. Kolita. You run
Sir, my lord,
the.
Annexure 23 was never served, my lord. Whether it was, my lord, disposed of or not. Thereafter, this order was issued.
The very basis foundation is very weak. Yes.
As per the order of this court.
Fishery, your fishery department, yes.
They have not approached the appropriate authority, my lord. That is why, my lord, in the order, my lord, itself written, my lord. However, since the decision of the waive of the revenue areas of the aforesaid period is not under the discretion of this undersigned, my lord, they have to approach the appropriate authority as per the orders of this honorable court, my lord.
Who is the appropriate authority?
Commissioner and Secretary.
Commissioner and Secretary already we have, my lord, Annexure 20.
20 page.
Page, my lord, 137.
What is the decision taken by the Commissioner and Secretary?
No decision, my lord, not yet. Not disposed of.
My lord, there is no endorsement of the department, my lord. They have submitted it or not, my lord. If
27/6/2025.
Yes, immediately after the order, my lord.
If your lordship peruse, my lord, original, my lord, 139, my lord.
There is one signature on the left side.
But there is.
But this is OC, office copy, not the signature of receipt.
My lord.
We don't think you have a case. You take instructions. Hard Sri and K. Kulita, learned counsel for the petitioner. Full stop. The as per the facts projected, comma, the petitioner, which is a Samabai Samiti, was settled with the Brahmaputra Part 1 and Dibang Nodi fishery for a period of 7 years from 2019-20 to 2025-26. Full stop. Initially, comma, there were certain designated fishing selling points, which however was subsequently closed with the condition that the sale can be made in the area of operation. Full stop. It is contended that the area of operation is far off and it is impracticable to make such sale, and therefore the petitioner was not able to make the sale and earn revenue, resulting in failure to deposit the kist. Full stop. The petitioner had earlier approached this court by filing WPC 5332 of 2025, which was disposed of wide and ordered at 24/6/2025, directing the petitioner to submit appropriate representation. Full stop. The petitioner, however, had submitted representation to the co-district commissioner, who by order dated 16/7/2025 had disposed of the same by stating that it was not the competent authority. Full stop. The petitioner claims to have submitted a representation before the commissioner of the department, which however has not been acted upon. Para. Miss S. Chutia, learned standing counsel, Fisheries Department, has however submitted that the petitioner had did not approach the appropriate forum in terms of the order dated 24/6/2025. Full stop. She has also pointed out that the co-district commissioner in the communication dated 16/7/2025 had come to a prima facie finding that no justification was there for exempting the dues. Full stop. She has also submitted that it is not clear as to whether the representation was actually submitted before the commissioner and secretary of the Fisheries Department. Para. Let notice be issued, returnable on 17th. Can you get the instruction? 17th of August. Miss Chutia, the learned standing counsel for
3 and 10.
1, 2, 3, and 10. And district you does for 4, 5, 4, 5, 8, and 9. MD Bora Standing Council Corporation 6 and 7. Extra copies. Forest is also there, 11. Forest or RR Gogoi, 11. Extra copies. Okay. Come up with instruction.
Obliged.
57 and 59.
Similar matter.
My lord.
What is this?
Regarding settlement of my lord ferry service, my lord.
Last occasion, Lordship directed me to take instruction. I have received instruction. my lord.
Why two cases, Mr. Laskar? By the
My lord,
same person?
One same person.
Different ferry
Two
service.
different.
Different ferry. What is it?
My lord, page 11 is the NIT, my lord. First one is for my lord Chandrapur Chiri under.
Oh, you are the highest bidder.
Highest bidder. my
You have given to somebody else.
Yes, my lord.
Why?
Because he is not responsive.
Not responsive. Why?
Because as per the NIT condition, Lordship, the zonal value of the land should be given, but he has given the market value. So his
No, my lord,
So he is the highest bidder, but he's not a valid highest bidder.
page 11, my lord, kindly, NIT.
But did you inform this to him?
No, no, my lord. My lord,
Lordship, regular settlement yet to be issued, will inform.
no, my lord, kindly have a look, my lord, NIT, my lord. Page 11, my lord.
Page 11.
My lord. The executive engineer inland, my lord, 1.
We have taken 3971.
My lord.
Okay?
My lord.
Yes.
My lord, this is the NIT, my lord. And now, my lord, this paragraph 2, tender published date, lordship get what?
Yes. Please.
3/1/2026,
Yes.
tender download date and time, my lord. Tender submission starts date, tender submission end date, and tender opening date online, time 27,
Yes.
my lord. Now, tender opening date was required to be uploaded in the online, my lord. Now, my lord, page 24 is the tender summary report. My lord, that is technical, my lord, comparative statement, technical.
Page?
Page 24, my lord.
24.
24, my.
Yes.
At serial number 1, my.
Hmm.
Abdul Karim Majumdar, my lord, status accepted, technical, my.
Yes.
All documents submitted as per NIT. Now, my lord, thereafter 26/6/2026, this was issued, uploaded, my lord, and thereafter the impugn order, page 27, my lord, 4th July 2026.
Page?
27, my.
27.
With reference to the subject cited above, I would like to inform you that till final settlement of the ferry service by the competent authority under the current tender process, it has been decided that following ferry services shall temporarily operated by valid highest bidder against their respective. Serial number 17 is the ferry service here in question, my. Now, my lord, NIT was issued, my lord, without giving.
How much is your value?
8 lakh, my lord.
Rupees 8 lakh.
8 lakh, page 21, my lord. And the private respondent is 7,60,000, my.
Yes.
Without giving the logical conclusion of the NIT, my lord, this temporary settlement was issued, my lord. And apart from this, my lord, my technical bid was accepted, my lord. Subsequently, they come with a plea, my lord. And apart from this, my lord, all these things are required to be uploaded in the official website, my lord. These things should be transparent, my lord. Behind the back, my lord, with all due respect, my lord, these things have been done, my lord. And till today, my lord, I am having the temporary settlement of the ferry, my lord.
Till today, he is operating. But from tomorrow, the highest bidder will operate. Plus, the petitioner did not annex the NIT condition with the writ petition, my lord.
But this instruction of yours,
Lordship.
where have you intimated that he has not been found to be technically responsive?
Because after
On the
opening
other hand, you have found him to be technically responsive at page 27.
yes, technically responsible because he has submitted the documents.
Yes.
That land valuation document will examine after opening of the financial bid only. After opening of the financial bid, we have seen all the documents for the financial bid. And in the financial bid document, he has submitted.
See, madam, there are two, it's a two-bid system.
Yes, Lord.
The moment you hold him to be technically responsive,
yes,
means that his documents are found to be okay. You should have held him to be technically non-responsive.
But his market value he has given in the certificate, not the zonal value.
Those reasons you should have to assign and declare him to be unfit.
Yet we will
It cannot come in by way of instructions. What is this going on? You are like somebody, you give him, and you don't like somebody, you oust him.
This is not my lord.
Where is the transparency?
They will issue some notice, I think.
What some notice?
Because as per
You take decision in the file and don't communicate. This is your transparency.
whether they have communicated that instruction.
Where is how have you given to the private respondent whose value is less by 40?
But he is not technically.
You have to declare him to be technically unfit. Where have you declared? By a written instruction like this.
But this is for me, Lord.
How can you declare this?
And page 24.
Is it transparent? Let him know.
Yes, because Lordship, as per clause 8 of the NIT condition,
You may have a good reason, but are you transparent?
that instruction I will get.
You put this on stay.
But Lordship, may clause 8, Lordship, may kindly have a look.
Clause 8, you have to come up with the transparent paper. That clause 8 you have not fulfilled.
That instruction I don't have, Lordship. They may have some.
Mr. Sharma, you're for whom? Sorry.
And balance hearing is basically.
We are not finding any fault with you. You are the second highest bidder, but he has been wrongly, unfairly dealt with.
So the settlement is yet to happen. The settlement will happen only on 1st of August.
So why not to him? Why to
No,
you?
The settlement is yet to happen.
So why temporary with you?
Temporary with me.
Why?
4th of July order.
Why?
Because the authorities have.
Because they like you very much.
Because the authorities have considered.
Sorry.
No, I'm not on that lawsuit. No, I'm not on the liking aspect. The authorities have considered, based on the NIT condition itself,
Yes.
that the document submitted by him.
But without
is of
his
the
bid, without his
point
bid
of-
being rejected by way of a transparent manner, we are not doing.
I agree on that. The fault of
We
the
need
authority here
to see that fairness and transparency are maintained.
Yes.
You may have good reasons. You have to be fair and transparent.
Yes, Lord.
It's not sin.
I agree with on that aspect that there is
Okay.
a fault of the authorities on not communicating to him about the lacuna of his papers.
See, once it is not communicated, everything will crop in. Why have you not communicated?
Better his position today. After the communication also, he cannot better his position because what is required was not submitted by him. Maybe the authority made a mistake.
See,
Not
Mr.
communicating.
Sharma, you can argue your case. You cannot argue the case of the department.
Because
Department, no. We are not finding fault with your bid.
Yes, Lord. My bid is because.
No, we are not finding fault with your bid.
Yes.
We are only finding fault with the decision-making process where his bid is found to be technically responsive and higher than you.
Correct.
Higher than you. In that case, why temporary arrangement with you? Maybe in the final arrangement, he can be ousted, saying that this is the reason for which you are technically out. And it comes to you. That's why, and see the wordings in the temporary arrangement. With reference to the subject, I would like to inform you, till the final settlement ferry service of the competent authority under the current tender process, it has been decided that the following ferry shall be temporarily operated by the valid highest bidder. That means he has held to be invalid.
But not communicating to him. Then I have seen. But then this order survives till only 31st July.
Which one?
This temporary order.
No. No.
No, what has been just now.
Till the final settlement.
Till final.
What has been just now.
Till the final
indicated
settlement.
At the council for the department.
Temporary already over the petitioner is operating.
No, this order. Yes, till final settlement. Put on stay this. Okay. Heard Sri J. Laskar, Learned Counsel for the petitioner. Full stop. As per the facts projected, comma, the petitioner. You are the existing lessee
Existing.
in both the cases.
In both, no, in this case only, my lord.
And the other one?
Private respondent. In that private, different private.
In 397, you are the existing lessee.
My lord.
It is the projected, it is the projected case, comma, the petitioner, who is the existing lessee, A line 2, it would nahi ba, huh? Who is the existing lessee, had participated in a tender process issued wide notice dated 3/1/2026 for leasing out the IWT ferry service at the Chandrapur Chiri for the year 2026-2029. Baki to naam to bele kabo, huh? Chandrapur Chiri jaga bele kabo. The petitioner contends that all necessary documents were submitted by him and his bid was found to be technically responsive. Full stop. However, vide the impugned communication dated 4 July 2026, temporary settlement has been given to the private respondent till final settlement is done. Full stop. It is submitted that in the said impugned communication, the private respondent has been termed to be the valid highest bidder. Full stop, para. This court vide the earlier order dated 29/7/2026 had directed Ms. M.D. Bora, the Learned Standing Council IWT, to obtain the necessary instructions, para. Pursuant to the same, comma, the Learned Standing Council has obtained instructions as per which the petitioner has not fulfilled clause 8 of the NIT, which pertains to the bid security, full stop. It is submitted that it is contended that the petitioner had submitted a certificate indicating the market value of the land and not the, which was not assessed on the basis of the zonal value of the land. Para?
I have also the certificate submitted by the petitioner.
The land valuation certificate submitted by the certificate, copy of the land valuation certificate submitted by the petitioner has also been, has also been obtained by her. Para? Let notice be issued, returnable on returnable on 17th of August 19th of August 2026. Ms. Bora, the Learned Standing Council, accept notice on behalf of respondent numbers 1, 2, 3. You are on caveat or you are on caveat? No. Sri A. Sharma, Learned Council, has entered appearance for the respondent number 4 and has accepted notice. Let extra copies be served. Para? Sri Laskar, the Learned Council, prays for an interim order. Para? The contours of exercising root jurisdiction is on the decision-making process. Full stop. The examination on such decision-making process has to be on the aspect of maintaining fairness and transparency. Full stop. It is not in dispute that the technical evaluation was done, which was communicated, which was uploaded in the system on 26 June 2026, and the status of the bid of the petitioner was held to be accepted as technical. Full stop. There is no indication anywhere on records that the bid of the petitioner was found to be technically non-responsive. Full stop. The instructions, written instructions submitted, obtained by the Learned Standing Council, do mentions the aspect of clause 8, comma, the same discussion is not found in the evaluation, technical evaluation. Full stop. It is not in dispute that the financial bid offered by the petitioner is higher than the bid of the private respondent. Full stop. In matters of distribution of state legitimacy pertaining to earning of revenue, comma, the aspect of revenue is one of the relevant considerations as held by this court in a catena of decisions. Full stop. This court is of the prima facie view that a case for interim order is made out and the impugned settlement order pertaining to the petitioner, pertaining to the present ferry service appears to be unauthorized, appears to be not in accordance with law. Full stop. Para. In view of the above, comma, the impugned order dated 4/7/2026 is suspended till the next returnable date.
Particular pericar is concerned.
Oh, yes. So far as the particular ferry is concerned, full stop. Let the existing lessee be allowed. No, let the the department would make arrangements to run the ferry till the final settlement is done in accordance with law.
Of 8 of the NIT condition of it.
We have said clause 8. We have written clause 8.
Deeply applied.
Clause 8 we have said.
Deeply applied.
It would be okay. Yes.
Both same.
59 is not the present lessee.
No, court has not.
We have not said present lessee. In only one chiri we have said present lessee. 59 also Mr. Sharma appears. Same. Same respondent.
Respondent different.
Different. Okay.
I am for 1.3.
Petitioner is same.
Okay.
Okay.
And was your value? The bid, financial bid?
Higher than private.
Okay.
Obliged.
Yes. Yes,
My
Mr.
lord, your lordship has fixed the
Sarkar?
matter today for filing of additional affidavit.
Filing of additional affidavit.
By the BTC.
Filed.
No, my lord, this is an instruction, my lord. Everything has been paid. And the grievance is the copy. Payment has been made, my lord. It is from the executive engineer.
Yes,
PWD.
Mr. Sarkar.
Your
We'll have it on Monday or
Yes.
Tuesday or Tuesday. We'll close this, okay? Heard Sri N. Sarkar, learned counsel for the petitioner, para. Miss Bora, M. Bora,
B. Bora for
B. Bora, B. Bora, learned standing counsel BTC, has however submitted on instructions that the amount in question has been paid to the petitioner. Full stop. In this connection, she has also produced the written instructions dated 14/7/2026. Full stop. Para. Sri Sarkar, the learned counsel for the petitioner, prays for little accommodation to enable him to obtain instructions. Para. List on
My lord, after my lord, on 10 or 11, my lord. Up to my lord.
why 10 and 11? Instructions you are to take.
My lord, my
On
state.
senior's presence, if it is required, will adjourn. If it is paid, what would be difference will it make? On 4th.
My lord, the matter, my lord, non-payment of contractual bill, my lord. As per information, my lord, the petitioner received, my lord, the amount, my lord. My lord, out of my lord 482,214, my lord, petitioner received, my lord, 4,16,969, my lord. My lord, 65,000, my lord, they have.
For that, you can go to the civil court. TDS. Okay. This item number
15, my lord.
Heard Sri Ellen Dihingia, learned counsel for the petitioner. Also heard Miss P. Chakraborty, learned standing counsel, Water Resource Department. Now you first you read. Also heard Miss U. Das, learned state counsel. Miss P. Chakraborty, learned standing counsel, Water Resource Department. Mr. Datta, you are also there. Sri H. Aliha, learned standing counsel, Finance Department. And Sri Satyajit Datta, learned standing counsel, Revenue Department. Para. The matter pertains to a claim for contractual dues. Full stop. The learned counsel for the petitioner, para, has however fairly submitted that during the pendency of the said petition, comma, an amount of rupees
4,16,969.
4,16,969
Lordship.
has been received by him. Full stop. He has however submitted that the claimed amount was more, being 4,82,214. Full stop. The Sri Chaliha, the learned standing counsel Finance Department, has however clarified that there has been TDS deduction and TDS deduction, and there is no outstanding as such. Full stop. Para. In view of the above, this court is of the opinion that there is no live cause of action which requires further adjudication. Full stop. Accordingly, the writ petition stands closed. Second up to all various meeting the boss. কি করে দেব? তিনটা লাগে বলবো। And second half will sit till 3 o'clock. 3 o'clock, okay? Our director is retiring of Judicial Academy. We have to go there. Justice Ali.
Lordship, regarding this instant writ petition, we have received some instructions. We would like to file our affidavit and Lordship may decide on the basis of this particular affidavit for final dispute.
Mr. Nath, which case?
This one, my lord, has been paying for that Assam House matter. It's pending for a pretty long time and
Assam House means Calcutta.
Calcutta, there's some bills, there's so many orders, my lord. Even in the order reflects this amount is admitted and all these things and the different papers. So last occasion, Lordship said, let them file an affidavit so that it is easier to dispose of the matter, my lord.
Yes, Lordship.
I think it will be required, my lord, because every time they give me new papers.
Third, Sri M. Nath, Learned Senior Counsel, assisted by A. Bhattacharjee for the petitioner. Para, Sri M. Bhuya, Learned Counsel representing the
PWD, Lordship.
Public Works Department, however, prays for some more time to file the affidavit in terms of the order dated 22/6/2026. Para,
Yes.
considering the above, 3 weeks further time is granted as final opportunity
Lordship.
to file the affidavit. Para, list on. 31st. 31, 2, 3. We'll have 24th of August.
My lord, he said
Lordship,
he
2
can,
weeks is also
2 weeks he can do it.
2
In
weeks.
fact, he wanted 1 week, in fact. but
Oh,
was given him.
2 weeks.
2 weeks. Lordship.
List on 18th of May. 18th of, not 18th, 17th of August.
August.
It was nice of him, my lord. Nice of him, my lord.
Lordship,
That you will know better.
He's nice with that.
Your internal arrangements.
Obliged, my lord.
Lordship, another request, it was my mistake. It would be the General Administration Department.
Not
because
PWD.
Not PWD.
GAD.
Lordship. Much better.
Representative. Mr. Chaudhary, we can record your name for PWD?
Yes.
Sri B. Chaudhary, Learned Counsel for PWD is present.
22.
May it please your lordship. The lordship, the petitioner herein has prayed for transfer of a IMFL off license, my lord, in her name, my lord. So, my lord, the license belonged to her deceased husband, my lord, who expired.
Readings exchanged.
Yes, ma'am.
Yes. You for Mr. Das for 5. Who are you? There is a dispute.
Yes, ma'am.
Then how do you resolve this?
Lordship, for that, my lord, we have already approached the civil court, my lord. Only herein, my lord, in this petition, my lord, I have prayed for transfer of a license, my lord.
Here
IMFL
also
license.
she is disputing.
Only that, my lord, there is no such rule that it cannot be in the name of the wife, my lord. Only that they are seeking, the authorities, official authorities are seeking for an NOC. And my lord, that has not been given to me by the
Mother-in-law.
mother-in-law.
But can we direct them? Can we force them to give an authority?
What happened, my lord, already she has been denied from all sorts of beneficiaries arising out of
Madam Bora, this forum may not be the correct forum.
but lordship may kindly
These are private disputes. You have to settle it out.
praying for to consider my representations I have filed, and only the issue is that she is also agreeing that she will from the profit arising out of the liquor shop, my lord,
If it is placed on record, we can direct them. Otherwise, if there is objection from Mr. Das, then direction of this nature cannot be. Are you agreeable to the proposition that you will share the profits?
take instruction in that.
Okay, you take instructions.
Yes.
In that case, at least we can direct consideration of representation.
Willing to share the profit, my lord.
Heard Ms. B. Vora, Learned Counsel for the petitioner. Also heard Mr. S. Sharma.
Yes, my lord.
S. Sharma, Learned Counsel representing the Excise Department. Footstep. 3 M. Das, Learned Counsel for the respondent number 5. Prays for time to obtain instructions regarding any amicable settlement. Full stop. Sri R. Talukdar Learned State Council is also present, para. In view of the above, matter is adjourned by 2 weeks to enable Sri Das, the Learned Council, for the response number 5 to obtain the instructions. List on, we'll have it on, we'll have it on 12th of August.
Yes, sir. I'm deeply aware.
MK Das.
I'm deeply aware.
This matter relates to non-payment of contractual liability, my lord. They have filed an affidavit. And they have brought on record two document letters which were only issued in 19/7/26. Only these ones, my lord. They are seeking some further clarifications from the executive engineer. One work they have admitted. Regarding the other two works, they are saying that there is a paucity of fund and they need further clarification. So, my lord, I think if the second.
This affidavit was filed on 23/7.
Yes, lordship.
Recently. So what clarification do you require?
Lord, the department had admitted one amount, man. And it's
On the basis of the affidavit, either you admit or you deny. If you
my lord,
admit,
we had admitted 3 rounds of works order, my lord. The other is not admitted, my lord. It stated that.
so for 3 we can pass orders. For the 4th, you can approach the civil
My
court.
lord, if I may pray, my lord, because that a particular executive engineer's office in response to an RTI reply has already admitted all the outstandings, my
My
lord,
lord,
including the part payments which he have already made. So, my lord, let that report come, my lord, thereafter.
See, the
second
affidavit has been filed recently. Now, after filing of such affidavit, is there any scope for bringing further instructions?
My lord,
Whatever has been done, matter is pending since 25.
in that case, my lord, may I pray for an order that the coordinates have been passing, my lord, that they will make a verification of everything and that let them make.
No.
If it is found admissible.
Unless there is an admission. We have diluted for if the admission comes by the competent authority by way of affidavit also. Till those extent to those extent we will be passing orders. We cannot ask verification. Verification is only on Ramshar Ali.
My lord, in that case, let this matter be lifted after a few days, my lord. In the meantime, if in case that admission again comes, we do not know. It may come, my lord. These are very petty amounts.
Since matter is pending since the March 2025, 1.5 years.
No, see, because if those
February 2025.
No, my lord, these two letters, my lord, were issued recently only, 19/7/26. So, my lord.
Heard Sri G. Rahul, Learned Counsel for the petitioner, as well as Miss D. S. Neog, Learned Standing Counsel, Irrigation Department, full stop. Para. Sri Rahul, the Learned Counsel for the petitioner, has submitted that in the affidavit filed on 23/7/2026, two communications of recent origin have been enclosed by which further clarification has been sought for. Para. In that view of the matter, he prays that the matter be adjourned so that further instructions may be obtained by the Learned Standing Council. Para. In view of the above, matter is adjourned to be listed on 17th of August.
No, similar matter.
Affidavit filed.
Yes.
Same player.
Yes, Mr. Agarwal.
My lord, the case relates to non-disbursement of central capital, central inter-subsidy under the NEAPP scheme for the period 2011.
Affidavits filed.
No, Lordship, some more time may be granted, Lordship.
My lord,
Somebody has filed affidavit.
only NetFee has filed. And
Who? NetFee?
NetFee has admitted their liability.
And Madam, you're for the central government.
Yes, Lordship.
You file your affidavit.
Lordship.
How soon? Pending since 25.
But last chance may be given, my lord.
No, this had come only for the second occasion. Notice was issued thereafter. Matter was not listed. I do not know why.
Last, it was listed on 23/6/2026.
Yes, then notice was issued on 21/2/25.
21 to 2025.
More than a year, matter was not listed.
This statement.
It was made returnable also.
3 weeks.
3 weeks. Strange. What to do? Yes, some will grant sometimes. And state utilized. Will you file affidavit? Okay. While the net fee and Hertz fee, R.K. Agarwal, learned counsel for the petitioner. Para. While the net fee represented by Sri Jidas has filed affidavit, the central government and the state government have not filed the affidavit. Full stop. Miss R. Devi, London CDC, and Miss Udas, London State Council, pray for time for enabling filing of affidavit in opposition. Para. Matter is accordingly adjourned by 3 weeks. 3 weeks, 25, 3 weeks to enable filing of such affidavit in opposition. Para. List on almost, you'll get almost 4 weeks. You'll get 21, 3, 21, sorry, 21, 8.
Of leisure.
31. 1, 2, 3. No, 3. Don't say 21. 21. No, we'll have it on 24th. 24th.
May I please, your lordship?
My lord, I'm entering appearance for restaurant number 3 and 4 today, lordship. So I have received the written instruction, lordship. I'll file affidavit, lordship.
Your private respondents?
No, but besides municipal board, lordship.
Okay. Let them file affidavit. Your name, madam?
KLR Yanthan.
Okay, please give heard Miss so learned counsel for the petitioner. Para. 3D also heard 3R Talukdar learned counsel for the state respondent. Para. 3D Das learned counsel has entered appearance on behalf of the respondent number 4.
3 and 4, lordship.
3 and 4. And has prayed for time to file affidavit in opposition. For last occasion, we said you will appear. Now, he has undertaken to. Okay. Para. Matter is accordingly adjourned by 3 weeks to enable filing of such affidavit in opposition. Full stop. List on 24th of August. Yes.
Lordship, my name may be reflected.
Name of 3 leaders be reflected in the cause list.
Lordship.
27. Yes.
May I please, your lordship, we have filed an IA for implement to the morning itself. So kindly give us some time.
Your name, madam?
P. Roy.
Ms. P. Roy, Learned Counsel has submitted that an application for implement has been filed
Today.
this morning.
Yes.
And not don't say this morning, today, which however has not been listed. Don't say no, has been today, which is required to be considered. Para. Also heard Sri S. Sharma, Learned Counsel representing the Excise Department. No, Agriculture. Agriculture Department. Not Agriculture, I think University. Para. Matter is accordingly adjourned to be listed on 5th of August, along with the IA stated to have been filed.
Okay.
Obliging.
May it please all receive?
Lordship, here, by as per order dated 19/6, we were supposed to bring some instruction on the basis of the instruction of Revenue Department. I pray for a short time, Lordship. I have not received any instruction.
What do you say?
Lordship, the Angus Council could not.
No, he is seeking some time. We'll grant some time.
Okay.
Okay. On the prayer of Sri B. Chaudhary,
PWD.
Learned Standing Council PWD. Matter is adjourned by further 2 weeks to enable him to obtain necessary instructions as directed earlier. We have seen respondent number 7, represented by Ms. Udas, Learned State Council, has already filed affidavit in opposition on 30/7/2026. So of 2026. Full stop. Para. List on. Give one excuse. Two excuse, not three excuse. Two excuse. List on 17th of August.
Obligations.
29. Bahadul.
My lord, this matter has become infructuous, my lord. Settlement was up to 30th of June, my lord.
Okay. Heard Miss S.B. Chaudhary, learned counsel for the petitioner. Also heard Priyas Datta, learned standing counsel PNRD, as well as Miss Udas, learned state counsel. Para. The challenge in this writ petition was against a notice, tender notice dated 19/8/2025 for settlement of the Mujuchar Talwa via Kuntirchar to Dhubri Parghat by the Palimari Gao Panchayat. Full stop. Para. The learned counsel for Ms. Chaudhary, the learned counsel for the petitioner has, however, submitted that the period of settlement is over and therefore she would not like to press the writ petition any further. Full stop. The aforesaid submission has not been opposed by the learned counsel for the respondents. Para. Writ petition is accordingly disposed of as being infructuous.
Like.
Until 32 to 48.
Please, madam.
Yes, Mr. Taludar.
So the short point, I was awarded a contract which was subsequently terminated. The IOCL has filed an affidavit which was served upon me yesterday. I will put in a short rejoinder by Monday, but my only request is if this can be taken up sometime next week, because my difficulty is this, my lords. A contract was awarded to me. After I commenced work, it was terminated. Initially a show cause notice, I was immediately suspended. Thereafter, I was terminated on the ground that certain documents were not produced by me at the time of the contract. Now, they have filed an affidavit primarily raising 3 points. One is on maintainability and 2 other points on merits. I can deal with it by Monday. The difficulty is that these are vehicles which are specialized for transporting LPG. Because of this suspension and thereafter the termination, these vehicles are lying idle from March 2026, despite being awarded a contract. So my only request is, if it is not inconvenient, I'll put in a rejoinder by Monday. I'll give him my advance copy. If it could be taken up sometime next week as per my lord's convenience.
Okay,
It's a very short issue, my lord.
Heard 3. All the matters are connected.
Yes, all are connected. It's just one matter. It's the same thing, man.
Heard 3. K. Talukdar, learned counsel for the petitioner. Petitioners in these cases. Also heard 3. M. Sharma, learned standing counsel. IOC.
My lord.
Full stop. IOC who submits that affidavit opposition has been filed yesterday. Full stop. While Sri Talukdar, the learned counsel for the petitioner, prays for time to file rejoinder, he has expressed urgency in this matter and has undertaken to file such rejoinder within a short time. Full stop. Para. In view of the above, let such rejoinder affidavit be filed and the matter be listed for consideration on 11th of August 2026. Tuesday, it's a Tuesday, we'll try to have it for final discussion.
I'm grateful.
So number 1. 3. SS Roy Learned CCC is present.
32 to 38. I'm
38. Up to 38, Mr. Talukdar, up to 38.
32 to 38.
I did 39. Yes, Mr.
Miller, notices were issued in this matter to the BTC.
BTC, Madam Bora.
In this matter, my lord, directions were to the district commissioner.
There was also an observation that pendency shall not be a bar for consideration and disposal of the representation. Have you done that? Who will do that? You or Madam? Okay, grant some more time, you get the instructions.
My lord, what has happened is this is a grid of national importance. And this transmission work has to be completed by a specific time. So my lord, 2 weeks may be given and matter may be fixed on a certain date so that they come up with something.
Yes,
Could-
who's
could-
appearing online? Yes, who are you?
He's assisting me, madam.
Okay, okay. When do you want?
14th, madam.
Can you come on 14th? Okay. Heard 3 R. Sharma, Leonard Senior Counsel, assisted by Madam, your name, sorry. B.
By Mr.
Team Magda.
Team Barngar, my lord.
T. Mangar
Yes, my lord.
for the who are appearing online for the petitioner, as well as and Miss B. Fukan. Full stop. Notice was issued on 22/6/2026. Full stop. Miss Udas, Leonard State Council has submitted that because of the rainy season, comma, the appropriate instructions could not be obtained.
Construction could not be done. That is the instruction.
Construction.
Yes, ma'am.
Okay.
Because of rainy
Because of
season,
the
construction could not be
inclement weather, because of the rainy season, comma, construction could not be done. Full stop. See, praise for some time to obtain detailed instructions. Para.
If it pleases my lord, it's not an issue of construction. This is an issue of removing the obstruction by the landowners who are not letting us go and plug.
Don't say construction. For the rainy season, the work could not be done. Work could not be done. Get proper instruction, madam.
Madam.
To obtain instruction. Para. In the interest of justice, matter is adjourned to be listed on 14th of August.
Obliged.
Yes, Mr. Tega?
The issue relates to my lord, debarment of the petitioner from National Highway Works for 1 year, my lord. On the last occasion, my lord, the PWD NH department has filed the affidavit, but my lord, we raise the issue of jurisdiction of the chief engineer, my lord. That issue has not been dealt with, my lord. As per MOT notification.
We remember this, man.
Yes. And my lord, on 4th of August, my lord, there is another tender, my lord. Tender will be open.
Lordship, this case is being dealt by Mr. B. Gogoi. He is on leads in court, and Lordship may take it up on Monday, Lordship.
Monday, man.
Today we'll rise early at 3 o'clock.
Yes.
Monday we'll have it.
Monday,
Okay?
Monday.
Monday will it be listed? Kali khula se nahi? Khula se nahi. Okay. While the petitioner is represented by Sri R.M. Deka, Leonard Counsel, comma, time has been sought for on behalf of Sri B. Gogoi, Leonard AAG, appearing for the Public Works Department. Para. As urgency has been expressed on behalf of the petitioner, do matters adjourned, comma, the same is directed to be listed on Monday. Give the date, please.
Court. Deeply obliged.
Yes.
Obliged.
43. May I please your lordship. After the lordship
Please
order,
sit. There are chairs vacant. Young ladies, don't stand in the court.
lordship,
Yes.
after the lordship's order dated 25/6/23.
This is item number?
Item number 43. Status quo order was issued, granted lordship. to us.
Okay.
And but respond number 6, the block development officer is helping some miscreants to disturb us, lordship, though we are operating. So lordship may kindly direct the respond number 6 not to disturb us, lordship, to collect.
Who is 6?
6 is block development officer.
He is disturbing.
Yes, he is sending some goons, lordship.
No instruction regarding this, my lord.
He'll send some goons.
Yes, lordship, to disturb us.
You lodge an FIR.
Lordship, lordship.
We need not advise you. Heard 3 R. Dhar, Learned Counsel for the petitioners, as well as Ms. B. Bora, Learned Standing Counsel, BTC. Footstop. Notice was issued on 25/6/2026 and an order of status quo was passed. Full stop. Para. The Learned Counsel for the petitioner has, however, complained that disturbance is still there on the behest of the respondent number 6. Full stop. Let this aspect be brought to the notice of the BTC authorities. Full stop. The petitioner would also be at liberty to lodge complaint before the police authorities if so advised.
Deeply obliged.
List on 17th of August to enable the respondents to obtain the instructions / file a final opposition, enable the respondents, enable the learned counsel for the respondents.
Obliged, Lord.
Yes,
Well, in this matter, I have received a recent instruction. They have said that they have informed that the GST of the petitioner is not updated. He has been written a letter has been written to him to update the GST to process it further. The matter relates to payment of non-payment of contractual.
no, that, when did you send the communication?
Very recently.
Have you got these instructions?
No, Lordship.
I'll just send it. I have a copy.
Can you tell us the date? Sridhinath, learned counsel for the for the respondent has submitted
On 30th of July.
that very recently. 30th is today.
Yesterday.
That yesterday a communication was issued to the petitioner to update his GST to take onward steps for release of the amount. Your name?
Anali on behalf of.
Anali, Sri Anali learned counsel appearing on behalf of Sri J.I. Borvia for the petitioner has prayed for some time to obtain instructions in this regard. Full stop para. List.
That is the copy.
A list on 17th of August, full stop. In the meantime, comma, the petitioner may take steps for updating his GST.
Nice.
I'm just handing over a copy to him also. He may not have informed.
The papers handed the written instructions dated 30/7/2026 along with its enclosures are made part of the records.
46.
Well, in 46, I have the instruction to appear for the respondent number 2, 3, and 4. Well, Lordship may give us some time.
Okay.
I'll
What about 1?
1? I have no instruction.
No, who is it served?
I find his designation is wrong. He is the additional chief secretary, but they have said it is principal secretary. There is no principal secretary in the Home Department as on today.
None appears for the petitioner on call petitioners. On the other hand, Sridhinath, learned counsel. Yes, here for the petitioner.
Yes, sir.
Why don't you appear?
Sincere apology, Lordship.
Okay, don't say none appears, huh? Notice was issued in this case on 22/6/2026, pursuant to which Sridhinath, learned counsel, has entered appearance on behalf of the respondent numbers 2, 3, and 4. He has also informed that so far as respondent number 1 is concerned, there is no principal secretary to the Government of Home and Political Department, and therefore certain rectification perhaps would be required to be done by the petitioner in arranging the proper party. Full stop. Srinath, the learned counsel, has also prayed for time to file affidavit in opposition. Full stop. Matter accordingly stands adjourned to be listed on 24th of August to enable.
Your Lordship, there's a small development in this case. In this case, Your Lordship, the respondent departments have communicated with us and have sought for our GST compliance certificate. And we are going to provide the same within a day or two. Your Lordship, they have started the procedure to.
24th, full stop. At this stage, your name?
Y.N. Mohanto, Your Lordship.
Are you on record, Mr. Mohanto?
Yes, Your Lordship.
At this stage, Sri Y.N. Mohanto, learned counsel for the petitioners have submitted that the respondent authorities have informed the petitioners for updating
Yes, Your Lordship.
their GST
Certificate. Yes.
certificates and steps for compliance of the order in question,
Yes.
and steps are being taken for such updation. Full stop para. Pendency of this case shall not be a bar for taking all necessary steps for compliance of the order in question.
Much obliged, Your Lordship.
47.
Your Lordship.
Yes.
As per order dated 23/6/26, we had taken steps, Lordship, and as per office note dated 20/7, the notice has been delivered, Lordship.
Notice. Who is to, Mr. Das?
It's the Secretary Assam Sah Kormosari Sangha.
The
Tungri Circle.
workmen or union.
Yes, Your.
Office note dated 28. 28 listening.
22, I think it's.
It took it is 28 and 23. 28/7/2026. Reflects that neither ID card nor unserved notice has been received back from the respondent to full stop. However, from the postal track report, the item is seen to be delivered. Para. In that view of the matter, and under those circumstances, matter is adjourned by 3 weeks to enable the respondent to appear if so advised.
Maybe continue.
To so advised. List on. Get now 3 weeks. List on 1, 2, 3. 24th of August, para interim order passed earlier to continue till the next date of listing.
49.
Mr. Barua?
Steps has been taken. I think private resident got the notice. Others, I don't know, man. Office notes.
Who is appearing? 7? Mr. Chetri? I've been in this because P1 and P2. Very to sir. P1, P2. P1, P2.
This is not been 40 years, but it is reflected in the process.
Is it a where? Okay. FDC is not a party. Mr. Barua?
By FTC.
Huh? District Fishery Development Officer, not by you. I think it will be a BTC.
Yes.
Fishery is also a transferred subject, I think.
Yes. At present, I
Who
think.
you are appearing for BTC?
I'm for
And-
respondent 1, 2, 3, 5, and 6.
Then 1, 2, 3. Deputy Commissioner, yes, Mr. Tal. What about 7? 7, Mr. Barua?
7 steps have been taken. I think he received.
There's nothing.
Office note, AD.
While the official respondents, while the official respondents are represented by their respective counsel, comma, as per office note, the council, comma, taking into consideration the office note dated 28/7/2026 pertaining to service of notice upon the respondent of 7, comma, matter is adjourned by further 3 weeks to enable the office to submit a fresh service report. Because neither ID card nor since AFDC is not a party, comma, registry is directed to delete SC AFDC from the cause list.
Obligation.
Did you? Did list on 24. 63, yes.
Lordship, an IA has been filed for correction of the LAC.
Lordship,
You have filed the IA.
Yes,
What is the correction you are seeking, madam?
Lordship, in order dated 13/7, there is paragraph number 5(1). There is LSC mentioned 107 Sorupatha LSC.
Yes.
But the applicants are from Sri Bhumi. And
Number
5(1).
51 Sribhumi.
No. 125 Pathar Kandi it should be.
Instead of 107, Lordship, it should be 125 Pathar Kandi.
125. Why did scrapped it? Because of the
Because of the order.
similar order. Oh.
Yes.
Madam, your name?
S. Laskar.
Heard Miss S. Laskar, learned counsel for the applicant, who by means of this application has prayed for a typographical error in the order dated 13/7/2026 passed in the connected WPC so and so 3567 of 2026. It is pointed out that in the directions contained in paragraph 7, comma, the name of the LSC has been wrongly written, wrongly stated, full stop. She has clarified that instead of number 107 Sarupathar LSC, it should be number 125
Lordship, Pathar Kandi.
Pathargandi LSC, full stop. The Miss S. Kotoki, learned standing counsel, Election Commission of India. Also heard Miss S. Kotoki, learned standing counsel, ECI. Who's three? Home Department, NRC. Sri D.U. Priti on behalf of JPANG for the Home Department / NRC. And Sri R. Talukdar, learned State Council, who do not object to the aforesaid prayer for para. In view of the above, comma, the order dated 13/7/2026 passed in WPC so and so stands corrected by reading the LSC as number 125 Pathargandi LSC instead of number 107 Sarupathar LSC, appearing in paragraph 5 within bracket small 1, full stop. Let this order be read as a part of the order dated so and so passed in the writ petition. I stand disposed of. I'm hearing now about Mr. Pathak not be possible to rise. What is the matter?
We have challenged some orders of holiday listing, so it will take some time. I just one small prayer. On 22nd, your lordship had indicated that the matters will be taken up for disposal at the admission stage.
We'll have it
That is perhaps wrongly come in the hearing column, your lordship. On 22nd of June.
I said that list these cases for hearing. Yes, said. Since urgency has been expressed by contending that the subject matter involved transportation LPG, list these cases for hearing on 28/7. So there is no wrong understanding. They have understood correctly. But we can have this for admission hearing, no problem. We could have held today. Today we have to rise early. And have it on a normal motion day. Motion days are possible to have. Hearings days is difficult. Paucity of time will not permit these matters to be taken up today. Full stop. This court has recorded urgency as expressed by the learned counsel for the petitioners. Full stop. List on list for admission hearing, we'll say. List for admission hearing on 11th. Can we turn 11th?
11th of
Tuesday.
It's a Tuesday.
Tuesday.
Very well.
Tuesday. Okay. Tuesday.
11th.
My lord, there are interim orders.
Interim order passed earlier to continue till the next date of listing.
Deeply overdue.
My lord, may I pray? On 11th, I'll be out of station.
Okay, tell us a date.
Can it be on
13th.
No, my lord.
Or sixth, 14th we can try.
My lord, 14, my lord, my senior will be out of station.
Then
my lord.
seventh also we can try, seventh.
7, my lord.
7th also out of station, out of station.
Oh, 7 out of the one.
Yes, yes, yes.
Can it one, my lord, on then
17th.
19, my lord?
19.
19, 1, 9,
We can try on 19th, Mr.
19th.
Pathak, 19th.
19.
Okay. Bucket to Nairo? Okay.
Deeply.